Okay. So now today, chapter 1 in module 4, we start with bail, anticipatory bail, conditions for granting the bail, rights for arrested persons, bail provisions. So this 478 to 496 section, what is part of chapter 1, this is covered under chapter 35 of BNSS, which is provisions as to bail and bonds. This is covered under that. So I'll be a little fast today so that we are able to cover that. Ask me questions at the end if you have any. Okay. So keep noting down. Open your BNSS and keep it with you. So section 478 says, in what cases bail can be taken? So let me do one thing. Let me share the screen 1 minute with the BNSS in place so that it's easier for you also to follow the screen. Okay. And let me share my browser. Okay. Can you see the screen? Just say, give me a thumbs up. You can see the sections, right? Okay, good. So this way it will be easier for you. Now, section 478 talks about in what cases bail to be taken, which is the title. Now, when any person other than a person accused of a non-bailable offense is arrested. So when a person other than a person accused of a non-bailable offense is arrested or detained without warrant by an officer in charge of a police station, or appears or is brought before court and is prepared at any time while in the custody of such officer or at any stage of the proceeding before such court to give bail, such person shall be released on bail. So we discussed this earlier also, that if the person is coming with a non-bailable offense, the bail will be immediately given in that case to the person, because there is no argument as such required for giving the person a bail, because the offenses what the person has committed is a non-bailable offense, provided that such officer of court, if he or it think fits, may and shall, if such person is indigent and is unable to furnish surety, instead of taking bail bond from such person, discharge him on his executing a bond for his appearance as hereinafter provided. So if that person is indigent, the court believes that person is indigent and unable to furnish surety. So somebody probably does not have that kind of money, that kind of people he could bring forward for him, his support. So instead of taking a bail bond from such person, discharge him on his executing a bond. So just a written confirmation is sufficient in those cases. So indigent people are people who cannot take care of themselves financially, etc. Now explanation: when person is unable to give bail bond within a week of the date of his arrest, it shall be a sufficient ground for the officer of the court to presume that he is an indigent person for the purpose of this provision, provided further that nothing in this section shall be deemed to affect the provisions of subsection of 135 or section 492. Notwithstanding, subsection 2 talks about notwithstanding anything in subsection 1, when a person has failed to comply with the conditions of the bond or bail bond as regards the time and place of attendance, the court may refuse to release him in a bail when on subsequent occasions in the same case he appears before the court as brought in custody, and any such refusal shall be without prejudice to the powers of the court to call upon a person bound by such bond or bail bond to pay the penalty thereafter under section 491, which we'll see later. So part 1 says if it's non-bailable offense, fine, the person will be released, and that is fine. If the person is indigent, only a bond is sufficient to be written, and the person could be released on that. In case the person is the explanation is the person is not able to give a bail bond within a week of the date of arrest, the officer of the court can presume that the person is indigent for the purpose of this provision, but it is not applicable with the uh, there is nothing in this section will be affect the provisions of section 135, which is inquiry as to truth of the information, or section 492, which is the, if you read the title of 492, it says cancellation of bond and bail bond. So in these conditions, it is untouched. Otherwise, subsection 2 says, notwithstanding anything, subsection 1, person who is not complying with the conditions of bail bond as regards of the time and place of attendance, the person is not coming, and the court may refuse to release him on bail. So basically, what is this section is talking about here is, this is an eligibility of bail. This section is about eligibility of bail, and subsection 1 says that the person on a non-bailable offense will be given a bail, and excluding those people. So though anything else, any other person could be tried for bail. So their willingness to do so while in custody, if they should be released on bail, and if they are expressed their willingness to do so while in custody or at any stage or before the court, this provision underscores the principle that the individual should not remain in custody unnecessarily. Considerance of indigence is also given there, where the person's status is could be time tested also by a week's time, and there could be a presumption of indigence which is mentioned, that if the person is unable to provide bail bond within a week of their arrest, it can be reasonably assumed that they are indigent for the purpose of this provision, and this presumption protects the vulnerable individuals who are indigent. Conditions for refusal of bail is subsection 2. So part 1 is conditions for giving bail, part 2 is refusal of bail. So subsection 2 says, if the person has been previously released on bail but fails to order the others to the condition regarding attendance at specific time or location, court retains the authority to refuse bail or subsequent appearance in the same case. And this reinforces the importance of compliance. The person has to be made compliant because of that. And consequence of non-compliance is that the court can retain the power to enforce conditions of bail by allowing penalties also under section 491 if person fails to comply with their bail bond obligations. So this promotion reinforces the importance of compliance with bail conditions in all these conditions where bail can be given and not be given, or could be not given further. And this facilitates the access to the bail, upholding the accountability of both the parties, and it is very sensitive also towards the socio-economic factor of the people who are subject to this particular section at that particular point. Moving to section 479 in the bail, subject of bail. So 479 talks about the maximum period for which under trial prisoner can be detained. Now, it says that where a person has, during the period of investigation, inquiry, or trial under this Sanhita of an offense, under any law, not being an offense for which the punishment of death or life imprisonment has been specified as one of the punishments under the law. So, not a very major crime, undergone a detention for a period extending up to 1/2 of the maximum period of the imprisonment specified for that offense. Under the law, he shall be released by the court on bail. So this is something which is giving a provision which is helping the accused also, and reinforcing the condition what the Supreme Court has been talking about is the bail is the rule, jail is the exception. So in that case, if it's not a very heavy crime the person has done, it's not a very major crime the person has committed, and the trial, inquiry, investigation, anything is going on, and if the half of the period of the punishment of such kind of offense is already there, then in that case the person could be released by bail, provided that where such person is a first time offender who has never been convicted of any offense in the past, he shall be released on a bond by the court. And if he has undergone detention for the period extending up to 1/3 of the maximum period of imprisonment specified for offense under the law, so in that case, the person will be, being a first time offender, could be released in 1/3 of the punishment time as well. While the provided further that the court may, after hearing the public prosecutor and for reasons to be recorded by it in writing, order the continued detention of such person for a period longer than 1/2 of the said period, or release him on bail instead of his bond. So, depending upon the hearing of the public prosecutor for the reason what the person PP will provide or APP will provide, he can order the continued detention of such person for a period longer than 1/2 also. So part 1, which said, in general, the rule where the person could be released on bail after 50% of the jail period, he could be detained for more than half in spite of being detained for more than half period of the said offenses punishment time. And or he can be released on a bail bond instead of his bond. So he might be released on a bond or a bail bond. Provided also that no such person shall in case be detained during the period of investigation, inquiry, trial for more than maximum period of imprisonment provided for the said offense under the law. So that no such person shall in case be detained if the punishment time is already completed for that particular said offense for which he is being tried. Now, explanation is in computing the period of detention under this section for granting bail. The period of detention passed due to delay in proceeding caused by the accused shall be excluded. So, whatever proceeding delay because of the accused has happened, that has to be subtracted. Maybe the person was absconding, he was not coming to the court, he has not make himself present for multiple times in the court, or whatever it is before the in between whatever has happened. Subsection 2 says, notwithstanding anything in subsection 1. Subsection 1 is talking about a very precautious way of keeping the right of the person to get a bail. If 50% of the punishment size is covered, or one third in case of a first time offender, or might be extended in spite of instruction of part 1 around the 50% of the offense period completed. In anything in subsection 1, notwithstanding that, and subject to the third provision thereof. So there is a third provision thereof where an investigation, inquiry, trial is in more than one offense or in multiple cases are pending against a person, he shall be not be released on bail by the court. So if there is more than one offense, because part 1 talks about giving consideration to people mostly who are first time offenders and in terms of minor crimes. So if multiple cases are there, in spite of not having the impact of being a very heinous crime or a very major crime, then also multiple crimes in terms of multiplicity, aggravates the situation. The Proviso 3 says the superintendent of the jail where the accused person is detained on completion of one half or one third of the period mentioned in subsection 1, as the case may be, shall forthwith make an application in writing to the court to proceed under subsection 1 for release of such person on bail. So this is something which is a tool given to the jail authorities also, which is seldom used actually by to release such people on bail who have completed one third or one half. One third for people who are first time offenders, and one half in general for people who are not having multiple such offenses running in parallel, and the people who are first time offenders. So basically, it talks about the entitlement to bail in this section. What we're talking about, entitlement of bail to the offender in this section, and after a certain period, he could be given his freedom back while the trial goes on. In case if the person has already covered the size of the punishment, the number of years, months for that particular punishment for which he's being tried, then of course he cannot be detained further. He has to be released on bail. But then in case, what are the special priorities given to the people? It is given in the entitlement given in this section. Subsection 1 says individual has to be detained during investigation, but they can be released on covering of half of the size or the trial size, punishment size of that particular offense in number of months or years. Provision of the first time offender is also very clearly given, where first time offender could be released on bail on one third. But then this is a discretionary power of the court. So this particular part is a discretionary power of the court, and uh, for the first time offender, etc. And they can prolong the detention beyond the stipulated time if the public prosecutor presents a strong sufficient ground and strong reasons for that. So this is not a free pass given by default to somebody. It's a discretion of the court, and court will make a judicial discretion around this to ensure that if this is applicable or not very carefully. So, but there is a maximum detention limit also, which I said is given. That is the what is something to ensure that nobody is imprisoned beyond the maximum imprisonment term for that particular offense for that person is tried or offense or being tried. So exclusion of delay caused by accused is given because it's his own liability and that those kind of delays have to be reduced. So that benefit has to be reduced for so for example, if the person has done already half of the punishment time, but 6 months of time he has delayed. So again, 6 months he has to wait for receiving a bail under this condition, because then 6 months of time he has something which he has consumed by the accused himself. An implication of multiple cases is considered as a violation or a defeating condition for the proviso one part where we talk about if it is not grievous crime which is done. So if in case of multiple cases, then they will not be automatically eligible under this provision because they have committed multiple such offenses or other offenses. So this is a greater risk for a repeat offense by the person. So this is we'll see read this section, this particular about the repeated offender risk, etc. Further in this chapter. Application for release is given one option given to the jails also, so that jails can also proactively go ahead and get rid of those people who are in the jails, because jails also uh, are monitoring. They are maintaining a register at one place where they know exactly what is the statistics, what is the number of the people inside the jail who are fully fulfilling these conditions, etc., etc., whatever given in this section 479. And they are a very fit case to come back and present such details in the court proactively to, first of all, injustice to given to such people, because they're also part of the law enforcement and the tail end of the judiciary's action. But then that is also something which will help the jails also to act, to work in a healthy way, because the loads of the jail also will go down. So it's a prevention of an arbitrary detention, which is given under this section 479. It's a balance of the right and the enforcement both of the persons. So it's a balance of right depending upon what kind of person, what kind of first time offender, second time offender, multiple offender, or heinous crime or non-heinous crime. So that way it balances the right, but it also keeps the control of the enforcement of the law. And then it brings a judicial efficiency that way by putting a judicial discretion. And protection of the vulnerable individuals are given. And it gives an additional tool in hands of the jail authority also to be party to this condition to facilitate or request facilitating bails for such people. So this is a very comprehensive and a very important one, talking about the bail conditions. Now let's talk about section 480, when bail may be taken in case of non-bailable offenses. So when a person accused of or suspected of, so is accused of or suspected of commission of any non-bailable offense is arrested or detained without warrant by an officer in charge of a police station, or appears or is brought before a court other than a high court or court of session, he may released on bail, but such person shall not be so released if there appear reasonable ground for believing that he has been guilty of an offense punishable with death or imprisonment of life. So this is in accordance with 479 also. The same considerations are made here also. So what is done by subsection one of one is, it is first of all filtering out anybody who could be somebody who is guilty of an offense punishable with a very heinous crime. Then subsection 2 of sub provision 1 says, such person shall not be so released if such offense is a cognizable offense and he has been previously convicted of an offense punishable with death, imprisonment for life, or imprisonment for 7 years or more, or he has been previously convicted on 2 or more occasions of a cognizable offense punishable with imprisonment for 3 years or more but less than 7 years. Again, a filter condition, which is criteria is taking away the repeated offenders, provided that the court may direct that the person referred to clauses 1 and 2 be released on bail if such person is a child or is a woman or is a sick or infirm. So in such conditions, only the exception can be given to subsection clause 1 and 2. So subsection 1, clause 1 and 2 is only given as an exception is a child, woman, or a sick or infirm. Provided further that the court may also direct that person referred to in clause 2 be released on bail if it is satisfied that it is just and proper so to do for any other special reason. So it is a discretion of the court given. It's a very, very strong tool in hand of the judiciary where they can help the justice to prevail. Just if we go concrete by such clauses and provisions, these rules and regulations will become hurdle to the justice system. To stop that to becoming a hurdle to the justice system, there is a way out given, in which is helping the courts to take a discretion to, in spite of this, also take a decision in the opposite direction, what is indicated by this section. Provided also that mere fact that an accused person may be required for being identified during investigation or for police custody beyond the first 15 days shall not be sufficient ground for refusing to grant bail if he is otherwise entitled to be released on bail, and gives an undertaking that he shall comply with such directions as may given by the court. So, also that the mere fact that an accused person may be required for being identified by witness. So, any identification parade, we read about that. If that happens by any witness during investigation, etc., for police custody beyond 15 days, it shall not be sufficient ground for refusing a bail. If the person is beyond the police custody of 15 days, the person could be still given a bail. Provided also that no person shall, if the offense alleged to have been committed by him is punishable with death, imprisonment for life, or for 7 years or more, be released on bail under this subsection without giving an opportunity of hearing to the public prosecutor. So this is again a filter condition given to stop release of any person who could be who has committed a crime which is of a higher order, but then this also adds an opportunity of hearing the public prosecutor. So this person who has committed such kind of punishment will be not given any bail until and unless it is opposed by the public prosecutor. And when the public prosecutor opposes, it gives the prosecution a chance to bring forward to the court to make a right decision depending upon what all could be presented against that person, by able to prove by the public prosecutor that probably this person could again commit the similar crime or other crimes. So he's a repeated offender. Subclause 2 says, subsection 2 says, if it appears to such officer or court at any stage of the investigation, inquiry or trial, in all the situations, as the case may be, that there are not reasonable grounds for believing that the accused has committed a non-bailable offense, but that there are sufficient ground for further inquiry into his guilt, the accused shall, subject to the provisions of section 492, and pending such inquiry, be released to bail on bail or at the discretion of such officer or court on the execution by him of a bond for his appearance as hereinafter provided. So if it is appeared that the such officer to the court that in any conditions, in any stage of the case, there are no reasonable ground for believing that person has committed a non-bailable offense, but there are sufficient ground that further inquiry has to be done into his guilt. In that case, the accused shall, depending upon the provisions of 492, which will come ahead and we'll speak about it, and pending such inquiry, be released on bail, because there is sufficient ground for further inquiry into his guilt. It could be going in either direction. He might be guilty, not guilty. And at the discretion of such officer of court on the execution by him on a bond. So in spite of this, there is an option of given of a discretion of the officer of the court. He will be released on the bail, but with the discretion of the court officer who will validate things on the realities on the ground at that particular point of time. But if it is done so, he has to be done on a execution of a bond for his appearance further. Subsection 3 says, when a person accused or suspected of the commission of an offense punishable with imprisonment which may extend up to 7 years or more, or of an offense under chapter 6, chapter 7 and chapter 17 of the Bharatiya Nyaya Sanhita, or abatement or conspiracy or attempt to commit any such offense, is released on bail under section 1. So the court shall impose the conditions. So if a person who is accused or suspected to commission of an offense which is punishable for anything which is extended up to 7 years or more, and which is something which is punishable under section so and so sections of Bharatiya Nyaya Sanhita, that is chapter 6, which is of the exclusion of oral evidence by documentary. I picked up the wrong index in my hands. So he has somebody who has done the offenses of the order of chapter 6. Normally, these are the crimes which is committed in terms of the offenses of the bodies. So chapter 6 says offenses affecting the human body. Chapter 7 talks about the offenses against the state, so which is murder, etc., and then offenses against the state in chapter 7, and chapter 17, when the offenses are done, for example, offense against property. So these cases of crimes or abetment or conspiracy or attempt to commit anything is happening. So in that case, the court has to be cautious and they have to impose conditions. And the conditions are A, B, C given here, that such person shall attend in accordance with the conditions of the bond. The such person shall not commit an offense similar to the offense which is accused or he is suspected of the commission. And subsection C says that such person shall not directly, indirectly make any inducement, threat, or promise to any person, which is normally any condition of the bail. And he will not tamper with any kind of evidence, etc. And may also impose the interest of justice, such other conditions. Maybe he will not be in the city, in the same city. He will be out in some other district, etc., etc. Subsection 4 says an officer of a court releasing any person on bail under subsection 1 or subsection 2 shall record in writing his or his reason for special reason for so doing. So subsection 1 and 2, whatever is given here for the person to be released of a commission of a non-bailable offense and where is a guilt has to be investigated, or it is something where an investigation trial is going on and sufficient ground for further inquiry, his guilt, etc. is there. Then so all those conditions, the they have to make a recording in any case. Any court which has released a person on bail under subsection 1 to may it consider it necessary to do so, directs that such person be arrested and commit him to custody at any point of time. And subsection C6 says, if in any case triable by the magistrate, the trial of a person accused of any non-bailable offence is not concluded within a period of 60 days from the first date of fixed of taking evidence in the case, such person shall, if he is in custody during the whole of the said period, be released on bail to the satisfaction of the magistrate unless for reason to be recorded in writing, the magistrate otherwise directs. So in case of a trial which is happening, so we understand a non-bailable offence when it happens, there is a prohibition of investigation to the police. It can only happen if the court asks for an investigation. Now, in such case, if there is a trial happening and the person has been in the custody during the whole period and 60 days have gone beyond the uh, first date fixed for the taking evidence in that case. Normally, it is done in a summary way, so it is very faster as compared to the bailable offences. But when the first date was fixed to take an evidence, from that point of time, if the 60 days has gone, the person has to be released on the bail unless there are reasons to be recorded in writing, the magistrate otherwise direct. So if there is, unless there is a reason, then they will not, otherwise they have to release them on bail. If at any time, subsection 7 says, after the conclusion of the trial, the trial is concluded of a person accused of a non-bailable offense and before judgment is delivered, the trial is over, judgment is remaining, the court is of opinion that there are reasonable grounds for believing that the accused is not guilty of such offense, it shall release the accused if he is in custody on the execution of him by a bond for his appearance for her here judgment delivered. So if judge already knows trial is done, that person is indicative of not being somebody who has created the guilt, then there is no point in holding that person, and the person has to just ensure that through a bond that he will appear to hear the judgment, whatever is being delivered, and to accept that. So this is a huge section from 1 to 7 when a bail may be taken in case of a non-bailable offense. So this is special case of non-bailable offense. This only happens if the magistrate orders a investigation further of the case in a non-bailable offense, which normally doesn't happen. So if that special case is happening, then it is an eligibility for bail under non-bailable offense. So in case of non-bailable offense being tried, what is the eligibility of bail? That is section 480 talking about. So subsection 1 says that the general condition for granting bail to individual arrested for non-bailable offence is written here in subsection 1 under subclauses 1 and 2, where it says there are reasonable ground to believe there are that there are guilty of any offence punishable by death of life imprisonment, or the offence is cognizable and the person has previous conviction also, such kind of thing. So that person cannot be released in those cases. Consideration for is further given for the first proviso also, which is for the first time offenders also. There is a judicial discretion also given, which is helping to in the second proviso also. If you, let's go to the second. Then there is a consideration for vulnerable people also given, who is a child, a woman, or a sick or an infirm person, but they can um, also give a discretion to the court that if it is satisfied that it just and proper to do so for any other special reason which the court can believe. Because it's a non-bailable offense, only on the indication of any such crime which the person might have done, which is a major crime earlier, only on those reasons, the person will not be released, or there is a cognizable offense which has happened probably if that is the case. Otherwise, normally it is a bit lenient in case of non-bailable offenses. Subsection 2 then says that at any stage of investigation or and whatever the trial stage is going on, if there is no reasonable ground for believing that the person has committed a non-bailable offense, then they may be granted a bail. So if even a non-bailable offense is not done by the person, if the court believes that, they may be granted a bail to and release upon executing a bond to their appearance. And subsection 3 says when a person accused of suspected of commission. So if the person involved in serious crime, punishable by anything which is exceeding 7 years or under specific chapters of BNS. So chapter 6, 7, and 17, if it is done that, then attendance is requested on conditions. So the court will put a condition in the bail bond like attendance required, prohibition of committing similar offense, prohibition against tampering with evidence, inducing threat, etc. to the witnesses and the people, or maybe being out of the city, etc., etc. That is given there. Subsection 4 talks about the court officer has to put all the reasons in writing, whatever is done. And of course, that is the documentation which is necessary. And it also helps to put a control on the arbitrary such kind of activity done by any magistrate. Subsection 5 talks about the rearresting authority. So in spite of releasing, there is an authority to bring him back in custody also. And there are time limits which are counted in subsection 6, which talks about that the non-bailable offense is not concluded within 60 days from the initial date set for the taking evidence, then the person could be released until and unless there are compelling reasons to not do so. And the post-trial provision is given in chapter subsection 7, which says that after the trial conclusion, but before judgment delivery, if the court believes the person is not somebody who has committed a crime or the guilt is not of the person, then they can release him on a written bond saying, I'll appear for the judgment delivery at that point of time. It is a specific section around the non-bailable offense, with the first provision talking only about a condition where the person, in spite of committing at the moment a non-bailable offense, might have somebody who has committed a bigger crime earlier, or there is a chance this person might again commit some kind of crime, a bigger crime also later. Otherwise, in all other conditions, in spite of giving an exception to the vulnerable person, this gives a protection of right to the people in case of the non-bailable offenses, and it gives a direction to also judicial efficiency and accountability by ensuring that whatever they are giving an order has to be in a writing condition. And it encourages a fair trial in case of non-bailable offenses where the person is, in spite of being tried as a special case for non-bailable offenses, are not put under any kind of detention unnecessary, which is not required, because at the end of the day, non-bailable offenses are not very big offenses, and that is why they are something which is categorized that way. Section 481. So after reading so big sections, this is one of the small section what we have in section 481, which talks about bail to require accused to appear before next appellate court. So before conclusion of the trial and before disposal of the appeal, the court trying the offense or the appellate court, as the case may be, shall require the accused to execute a bond or a bail bond to appear before the higher court as and when such court issues notices in respect of any appeal or petition filed against the judgment of the respective court, and such bond shall be in force for 6 months. It's a time-bound bond. And if such accused fail to appear, the bond stands forfeited and the procedure under 491 will apply, which is the third last section we'll read today. So this is something which is a special case of bail where an appeal has been filed against the judgment of a lower court. So for example, there is an appeal which is filed and the judgment is adverse in the nature of the victim or the prosecution. Then in that case, they go for an appeal. But as this is an adverse or an impugned order, which is in eyes of the prosecution or the victim, it is an impugnment order against uh, his interest. Then he or she will file an appeal to the against the judgment of this lower court to a upper court. And in that case, there is again the person has to be present. And in that case, that before conclusion of the trial and before disposal of the appeal, the court which is trying the offense or the appellate court, whichever be, application could be done in both the cases, shall require an accused to execute a bond or a bail bond. So you can apply in the court which has uh, into the appellate court also, or in the previous court also, that there is something which is appeal is going on, and kindly please ensure there is a bail bond which is has executed to ensure that the accused appear before the next appellate court. Or it could be made in the appellate court itself, saying that we are filing something as an against an impugn order from the trial court or the lower court. Please first of all execute, help us, put a bail condition so that the person will appear into the next appellate court. So it's a subsection 1 mandates that before concluding the trial or disposing of an appeal, the court adjudicating the offense on the appellate court must require the accused to execute a bail bond. This bond serves as a commitment that the accused will appear before a higher court when summoned in relation to any appeal or petition concerning the judgment. This requirement reinforces the importance of judicial process continuity. So the bond executed by the accused shall remain in force for only 6 months. This allows sufficient time for the appellate process to unfold. So in the other way around also, if the accused is also making an appeal, then also in that case, the accused has to put a bail condition which is only applicable for 6 months. So if as a trial court, so example 2, so if there is a trial court where then appeal has to be gone for the accused to the appellate court that my bail has been cancelled and I've been punished and blah, blah, blah. So in that case, if an appeal is being made, a bail condition is granted only for 6 months, because then it is subject of the appellate court to ensure continuity. So it ensures a compliance to the accused also, that if the accused fails to appear as required, the bond will be forfeited. So the person will be given only 6 months of time, and that is the protection which is given. There is alternate also something given, like, for example, there is a trial court which has rejected the bail initially, and there is appeal which has forwarded to the, say, for example, to the High Court. In those cases also, following section 481, the High Court will come back and say, I can only give a protection in that sense that until and unless the trial court comes back and decides on the matter, you have a protection against any kind of detention by the police, but the protection is subject to the final trial result from the trial court. So in either of the cases, the bail has to be there to require accused to appear before next appellate court is a time-bound bail, which is given only for 6 months of time. After 6 months of time, that bond will be, uh, if the accused fails to appear, the bond will be forfeited. Because in the other case, the accused has also given a bail bond, received a bail bond or applied for a bail bond to ensure that he is present outside and his freedom is not curbed or is not detained by the police, and that can not be given for unlimited time like a normal bail. It's only for a 6 month it can be given, so that he actually goes ahead and makes an appeal into the court and appears around that. Because if it is given for unlimited time, the person can use it as a default bail. Section 482 talks about the direction of granting a bail to person apprehending arrest. So a person who is apprehending arrest, what is the direction for grant of bail to such persons? So when a person has reason to believe that he may be arrested on an accusation of having committed a non-bailable offense, he may apply to the High Court or the Court of Session for a direction under this section. And the court may, if it thinks fit, direct that in the event of such arrest, he shall be released on bail. So in case of the person who is apprehending, some kind of arrest will happen to him. And in case of some kind of accusation which can happen to him in connection to some kind of non-bailable offense, then he can apply to the High Court or the Court of Session for a direction under this section to get a direction which which will direct that in the event of such arrest, he shall be released on bail immediately. Now, when a High Court or the Court of Session makes a direction under subsection 1, it may include such condition in such directions in the light of the facts of the particular case. So, of course, in light of the facts of the case, they will do, and as it may think fit, including subclauses 1, 2, 3, which says a condition that the person shall make himself available for interrogation by a police officer as and when required, a condition that the person shall not directly, indirectly make inducement, threat, or promise of any person acquainted with the fact of the case, etc., etc. And number 3, a condition that the person shall not leave India without previous permission of the court. So, and such other condition which may be imposed under section 480, which you have seen, as if the bail were granted under that section. So, basically, the person apprehending arrest might get such kind of anticipatory bail with when he's apprehending an arrest, but it has to be definitely something which has to be also facilitating the justice system as well. So it can be given on if the court may think fit, but it has to include certain conditions like he has to cooperate in the investigation. He has to ensure he is not obstructing somebody to appear in the court, is not threatening, inducing anybody, giving money or showing a gun, a condition of not leaving the country without the permission of the court, etc., etc. And the other conditions which may be imposed under subsection 3 of subsection section 480. Now, subsection 3 says if such person is thereafter arrested without warrant by an officer in charge of a police station on such accusation. So, for the same accusation, if the person is arrested without a warrant by an officer in charge of a police station and is prepared either at the time of arrest or at any time while in the custody of such officer to give bail, he shall be released on the bail. And if a magistrate taking cognizance of such offence decides that a warrant should be issued in the first instance against the person, he shall issue a bailable warrant in conformity with the direction of the court. So immediately, automatically, this thing will happen. And subsection 4 says nothing in this section shall apply to any case involving the arrest of a person or accusation of having committed an offence under section 65 and subsection 2 and section 70 of Bharatiya Nyaya Sanhita. So if the person who is arrested in these conditions are, if subsection 4 says that nothing in this section shall apply in case where the arrest of the person is under the sections of rape and under the sections of gang rape. So rape and gang rape, this is not applicable. Otherwise, this is applicable. The person can not seek a anticipatory bail when he is apprehending an arrest in case of a matter where he has committed a rape or is a party to a gang rape, and this gives an automatic uh, exclusion in case of applying for such of directions from the higher courts. So this is a legal avenue, which is an application for pre-arrest bail. So it's a pre-arrest bail which is given, then it is only automatically utilized at the time when the actual arrest happens, and then it is automatically executed. So subsection 1 talks about the individuals who has reason to believe that they are at a risk for non-bailable offence and they apply to the High Court or the Session Court. Court's discretion and condition is given in subsection 2, where these 4 conditions have to be given: cooperation with the investigation, prohibition of any inducement or any threat or any prohibiting anybody, and ensuring that the person will not leave the country or the place, and then he has to comply with the conditions under section 480. Release upon arrest when it has to happen. Subsection 3 says that who has given this pre-arrest bail subsequently is arrested must be released on bail upon request. So person must be released because there is a direction in that direction from the High Court or the Session Court, and any time of when they are arrested, it is automatically executed. And if the magistrate which directs to issue a warrant, this must be done in the form of a bailable warrant. So in alignment with the court direction, so the magistrate will also take a cognizance of such offence when they decide that a warrant has to be issued in the first instance of that against the person. Then also he shall issue a bailable warrant in conformity with the direction. So the magistrate will also, what he will do is the magistrate will also give a bailable warrant also to that person in that case, because we know that the warrants are issued with some kind of conditions, and in case there is a pre-bail already taken, then in that case it will be considered as a warrant with a bailable warranty confirmation, and then the conditions will be accepted and bail condition would be considered fulfilled and the person's liberty will not be curbed. Subsection 4 talks about that it does not apply into the cases of uh, some kind of activities like rape or gang rape, etc. So there is no provision of getting such relief from High Court and Session Court as a pre-arrest bail. So this is a preventive legal measure which is given a provision where it's a jurisdiction of the High Court and the Session Court where they can listen to the facts, they can understand, apply their mind and apply the judicial discretion. And if they are aligned with the principle of justice, they can give a direction that this person is eligible for a direction given in his behalf for the offenses for which he has applied for the pre-arrest bail would be given a bail immediately the moment he is arrested without warrant. If it's through a warrant, he has to be given an instructions to be of a bailable warrant in conformity with this direction. It's a judicial oversight which is given at the first place when this kind of instruction is given, and this enhances the cooperation with the law enforcement because this is something which might be motivating the persons also later to cooperate with uh, the law and order to ensure the justice prevails and the trial is completed successfully, because in other way the person would have escaped. Section 483 talks about special powers of High Court or Court of Sessions regarding bail. Now, we talked about in the previous section about the powers of the High Court and Session Court being able to give a pre-arrest bail. So, it talks about what are the powers of the High Court or the Session. So, subsection 1, 2, 3 are drawn here. Subsection 1 says a High Court of Session may direct, clause A, that any person accused of an offence or and in custody be released on bail. And if the offense is of the nature specified in subsection 3 of subsection 480, may impose any condition which is conditions necessary for the purpose of mention in that subsection. So they have a power to release anybody on bail of a person accused of an offense and is custody to be released on bail if the offense is of a nature specified in section 480 in a subsection 3. So what does the subsection 3 says? It says when a person accused of suspected of a commission of an offense punishable with chapter 6, 7 and 17 of the BNS, which we saw as a bodily or something against the nation or something against a property. So if the offense is of nature specified in this one section, may impose any condition which is condition necessary for the purpose mentioned in that section. So they can, these courts are allowed to give a bail, but in such and such cases, which is in 483, and the conditions which are given in 483 also as sub clauses ABC, that person will come and make an attendance, he will not commit a similar offense, or that such person will not directly, indirectly interfere with the delivery of the justice, in a nutshell, if we say. So in that case also, these courts can give a pre-arrest bail or any kind of bail. Subsection B says, clause B says that any conditions imposed by magistrate when releasing any person on bail be set aside or modified. So they have power to either set aside what conditions were given or modify it also, provided that the High Court or the Court of Session shall, before granting bail to a person who is accused of an offense which is triable exclusively by the Court of Session, or which though not so triable is punishable with imprisonment of life, give notice of the application for bail to the public prosecutor unless it is for reasons to be recorded in writing of opinion that it is not practicable to give such notice, provided further that the High Court or the Court of Session shall, before granting bail to a person who is accused of an offense triable under rape or gang rape, give notice of the application for bail to the public prosecutor with a period of 15 days from the date of receipt of the notice of such application. Let's read the further sections also. We'll talk once because all are connected. Subsection 2 says the presence of an informant or any person authorized by him shall be obligatory at the time of hearing of the application for bail to the person under section of rape and gang rape, and the High Court or Session Court may direct that a person who has been released on bail under this chapter be arrested and commit him to custody. Now, Section 483 is something which is talking about the authority of giving bail, which are special powers to the High Court and the Session Court. Now, subsection 1 allows them to give a release person accused of offenses and currently in custody, and includes the uh, provisions in case of under section 483, how it is mentioned. They also have a power to modify or set aside any conditions which were imposed on the person through the bail. So they can set aside completely or they can modify it also. That is subclause section 1 talks about this, A and B. Then there is a notification required for the public prosecutor, which is mentioned there, which is the first proviso talks about that the before granting bail for offences that are exclusively triable by court of session, which means a bigger order of crime, or those punishable by life imprisonment, so heinous crimes, the court must notify the public prosecutor. So these courts will first notify the public prosecutor, and this provision ensures that the prosecution is given an opportunity to ensure that in that perspective that bail application is challenged, and promoting a transparency and consideration of the public interest, because this is a crime against the state. It is something which is impacting the public in general. So if it is a case of an order of a something which is triable at the session court, in that case it is something where the these courts have to go back and inform the public prosecutor, and it has to be challenged thoroughly. In the second proviso, then it says that, so first one, this proviso, second one, this one, which talks about then that the bail application concerning the rape and the gang rape, a notice also given to the public prosecutor within 15 days of receipt of application. So within 15 days of receiving of such application, immediately. Why 15 days given in this condition? Because bail conditions, bail cases, rape cases has to be tried on a faster track. So within 15 days, the PP has to be given a notice of the receipt of such application, so that the PP can come back and challenge it on the grounds why it has not to be given. So the first part, if you say, is talks about the power they have given, or 483 special powers, where these cases related to so and so chapters of Bharatiya Nyaya Samhita has to be addressed with some special considerations, and they also have power to modify or set aside conditions of the bail. But then it is considerate about the serious level of crimes which is being tried in the session court, which is an identification condition. That way it has to be informed to the PP, or if it is a condition of rape, within 15 days an application has to be going to the information notice, has to be going to the PP that such an application has been made. Then subsection 2 and 3 are given there. 2 talks about the obligation of informants present. Now, in case of any kind of informant, unauthorized representative is there, then at the time of the bail application, this person has to be there, because they will support the cause of the victim in such rape and the gang rape cases. So in those cases, the decision when it is has to be gone. Although you have informed the public prosecutor, the court has informed to be challenged, they also inform the people who have informed in this case, who have been party to this case in the interest of the victim, to also additionally come and challenge. So it is also putting a blocker through the same section where it is giving a liberty to give bail in these conditions also. And number 3 talks about, subsection 3 says that the authority to rearrest is also there, where the High Court or the Session Court can direct a rearrest of individual who have been released on bail. They can also give a order to rearrest the person, so that the court will have a necessary power to ensure compliance with the ongoing legal process and reinforce the authority in bail conditions. So in nutshell, if we see in short, 483 says bail can be given by these courts on any subject, even for the 65 and 70 sections of BNS, which is rape and gang rape, but with a special precaution by, in case of it's a crime of higher order which is being tried of session, or a sexually offensive crime against a woman, there are special precautions given, and the court which is giving bail, although they have also have a power to turn it around and rearrest the person also, which is an authority which is given to the courts. Let's go to section 484. We were talking about amount of bond, etc. So amount of bond and reduction thereof. So the amount of every bond executed under this chapter shall be fixed with due regard to the circumstances of the case and shall not be excessive. A bond has to be balanced. It cannot be excessive because we are not doing a financial penalization of the person. We have to ensure the bonds are executed to the level reasonably so that the person comes to the further proceedings and etc. wherever is required. Number two says the High Court or the Court of Session may direct that the bail required by a police officer or magistrate be reduced also. They can come back and ask to reduce also, which may be reduced also under their instruction. So it is a determination of the bond amount, which is we talk about in 484. We'll be talking about releasing on bond, etc. But this talks about the amount. So it mandates that the amount of the bail should not be uh, too high and it cannot be too excessive. So it's a reasonable level, it has to be there. And it is very, very important that the directive for that amount has to be judiciously given by the court, and that is what is has to be aligned with section 484. An authority to reduce bail amount is also given a power to the High Court or the Session Court, where we have seen in 483 their power to give bail in any condition, and this empower them to reduce the bail amount also, even if it is challenged, and they can also reduce it, which is imposed by the magistrate or the police. So two things which comes out here. One is whatever bond we have been talking about until now, or we'll talk further also, the amount of the bond has to be balanced and reasonable. And number two, these courts have power to reduce also, which has been asked by a magistrate or police. Now, section 485, which talks about bond of accused and sureties. So before any person is released on bond or bail bond, a bond for such sum of money as the police officer or court has the case may be think sufficient shall be executed by such person. And when he is released on a bond or bail bond by one or more sufficient sureties condition that such person shall attend at the time and place mentioned in the bond and shall continue so to attend until otherwise directed by the police officer or court as the case may be. Because these are the people who control the presence of the person who is accused in terms of for investigation by the police officer or for the trial by the court. Subsection 2 says, where any condition is imposed for the release of any person on bail, the bond or the bail bond shall also contain that condition. So that will also have that condition written there. Subsection 3 says, if the case so requires, the bond or the bail bond shall also bind the person released on bail to appear when called upon at the High Court, Court of Session, or other court to answer the charge. And subsection 4 says, for the purpose of determining whether the sureties are fit or sufficient, the court may accept affidavits in proof of the fact contained therein relating to the sufficiency of fitness of the sureties, or if considered necessary, may either hold an inquiry itself or cause an inquiry to be made by magistrate subordinate to the court as to sufficiency of fitness. So these are the precautions which are given under subsection 4 of the section which talks about the execution of bond. So bond where it is executed. So how the bond of accused and sureties are executed, which is section 485. So it says subsection 1 says that the before any individual can be released on a bond or a bail bond, they must execute a bond for an amount deemed sufficient by the police officer or the court. And this bond signifies a financial commitment to comply for a future legal obligation which you have to deposit, specifically attending a designated hearing. And the provision mandates that one or more such sureties must also execute a bail bond, ensuring further backing of for the individual's compliance. So that is also something they have to ensure. Now, condition for attendance is something which is given in this section, which talks about that the bail bond must be conditioned upon the accused agreement to attend at the specified time and place, and so it has to be mentioned there. And this obligation to appear in the higher courts is also covered under this bonds of accused on sureties, which is subsection 3, which talks about the same and says, if necessary, the bond and the bail must also require the accused to appear when summoned by the higher court, court of session, or other court to respond to charges. And this ensures that accountability of higher judicial authority is also part of the bail condition, that can also be part of the bail condition, that you will appear for so and so court cases in case the matter goes to High Court, Session Court in this connection or Evaluation of the sufficiency is something which is done by the mentioned in subsection 4, that it is fit or sufficient, and that is something they can determine that the sureties who are presented are sufficient or not. And these kind of affidavits are that attest the qualification of the sureties may conduct. So basically, what are the conditions which are tested? So normally, if you go and ask for a surety, what papers they have to bring in? They have to bring in papers of their identification that they belong to the local place and there are local persons. They are not from other places. What could be the ID? Ration card, Aadhaar card, etc. Then the surety also has to ensure that they're financially stable people. They are also somebody who has some financial ground to support. So that is why their Form 16 or their other such financial documents which are recognized by the court, those also have to be presented, which is again something which is check of a fitment. And then sometimes they have to also make an affidavit that they don't have a such any kind of immoral or a criminal background, or they are not part of any kind of immoral or criminal activities also. So all those things are something which gives a fitment or fitness of a surety, which is considered under section 485. And if it is considered necessary, in some cases, if it is necessary, the court may inquire itself. They may ask for some more papers, some more details. Verbally also they can examine, or cause an inquiry to be made by a magistrate subordinate to the court. They can ask some magistrate to validate the surety about their fitness before they can go back and uh, accept that bond or the surety, in that this case the surety. And that is something which is mentioned under board of accused and surety under section 485. Section 486 says declaration by surety. So every person surety, standing surety to an accused person for his release on bail, shall make declaration before the court as to the number of persons to whom he has stood surety, including the accused, giving therein all the relevant particulars. So this is something which is to make the person accountable, that he is not somebody who is in a business of giving sureties. Or even if he's not in a business of giving surety, he is somebody who is capable financially also to handle those many penalties, etc., and considered fair enough to stand for the number of sureties possible for that person. So it should not be, n number of people, one person could stand surety at any point of time concurrently. So this is a requirement of a declaration by the sureties they have to give, that this is an accused person who is released, and must formally declare that they have to declare they are not surety for how many people, and including the person for whom we are currently standing as a surety. So that those details has to be added there. And the purpose is, as I said, it promotes a transparency, and it discloses the number of surety. The court can better evaluate the fitment, as we see in the previous section, that is that could that person be actually be surety for so and so numbers and number of people, or how many number of people. And then this is something which is a very, very key aspect. Accountability of the surety is also, which is evaluated and ascertained through this particular section, which is an enhanced judicial oversight. So they are going beyond the checking the person who is capable to be or fit to be surety as another dimension of the check, where how many people you are standing surety for. And it's a financial responsibility basically, so that they should also understand, will the person who has proved his financial capabilities, etc., by the section 485, is he capable to do it for one surety or two surety as well? So this is also something which is validated under the section 486, so that the clarity and the sound uh, base is created for the legal proceeding. Because if the surety itself is defective, then it's a risk. Section 487. This is a section talking about discharge from custody. So the section says, as soon as the bond or bail bond has been executed, now whatever we have done, we have ascertained the person is eligible for a release or not. He could be released on a bond or a bail bond or sureties, etc., or not. So once it is all done, then we check the sureties and we ascertain everything. Now everything is fine, and the bond or the bail bond has been executed. The person for whose appearance it has been executed shall be released now, because that is the purpose. And when he is in jail, So somebody might be in the custody, in the jail. The court admitting him to bail shall issue an order of release to the officer in charge of the jail, and such officer on receipt of the order shall release him. So the person, if he is in hands of the police, will be released immediately. If he is already somebody who is languishing in the jails, then he can be released by the order of this particular court to the authorities in the jail. Subsection 2 says nothing in this section 478 or section 480 shall be deemed to require the release of any person liable to be detained for some matter other than in respect of which the bond or bail bond was executed. So in this section, nothing in this section 478 or section 480 shall be deemed to be require the release of any person liable to be detained for some matter other than that in respect for which the bond or bail. So person can be released only for the subject matter of the bail bond. So bail bond has a clear detail about which offense, what, but it is generated under a certain registered case in the court. And then for only those reasons, the person could be released with the conditions which are endorsed on that particular bail bond. So basically, this is a section which says a person has to be released immediately once the bail bond has been executed. And order from release from the jail can also happen through this. And it is a responsibility of the jail officers then to release such person. And there is a limitation given that the provisions for release do not apply if the individual is subject to detention for reasons not related to this section 478 or 480, anything which is not related to that particular release, then the person for which the bail is being executed, this is not applicable beyond that. The person will not be released then. So this is an efficiency section which talks about discharge immediately. Now the bond conditions are completed and protect the unlawful detention immediately. And there is a clarity in the legal procedure based on that and the accountability of the judiciary also is shown under this section. Section 488 talks about power to order sufficient bail when that first taken is insufficient. Now we have taken bail, power to order sufficient bail when first taken is insufficient. So if through mistake, fraud or otherwise, insufficient sureties have been accepted, or if they afterward become insufficient, the court may issue a warrant of arrest directing that the person released on the bail be brought before it and may order him to find sufficient sureties and on his failing so to do may commit him to jail. So, but there are two conditions here. One is by any mistake, for example, some evaluations had happened and the number of surety and amount, etc., has not been evaluated properly, or some clerical mistake, typing mistake has happened, or through some fraud, something has been induced and it is by or some other reason, insufficient sureties have been accepted, etc. Or if it becomes afterward insufficient, so maybe something bigger has been coming out in the court's notice, and it becomes insufficient. More surety is required. In this case, the court may issue a warrant of arrest to the person who is released on the bail and to be brought before it and may order him to find sufficient surety. So this is something which is happening once everything is accepted and the person is already released on the bail. But then a recognition of insufficient surety happens by mistake, fraud, or otherwise any other condition. In that case, section 488 is applicable and the warrant is issued and the person is brought back, and the person can only be then again released by putting that additional surety or the money, etc., or his failing so to do so may commit him to the jail. He might have to go to the jail. And in case of a fraud, the court might decide also to send him to the jail without even accepting any further sureties, but then completing what was required earlier. So that is something which is requirement of a provide a sufficient surety condition. And if it is failed, then the person has to be forwarded to the jail in terms of a consequence of a non-compliance. So it safeguards the integrity of the bail process. What it is safeguarding is the bail process. Bail process integrity is why safeguarded, because the bail conditions have to be done under so-and-so condition, have to be under a reasonable amount, financial amount, and the surety. So that is the basic process and requirement of a bail condition. So if the bail conditions integrity is violated, where something by some reason of mistake, fraud, otherwise, right amount has not been charged, right surety has not been deposited, right surety has not been brought received. So in all those conditions, it is power to safeguard the integrity of the bail process by plugging that loop, the hole. And this is a judicial correction which happens. It's a judicial oversight with just a judicial correction, and this is something which is preventing an abuse of a bail. So persons might also do abuse by fraud, or it might have happened because of some kind of mistake, etc. But then abuse of the bail condition cannot happen, because then it's an unnecessary benefit taken by the person beyond what he's uh, allowed to take in conditions of the bail's condition, which is he's allowed to take benefit of. Now, this is something completely in a different direction, which says discharge of sureties. So all or any sureties for the attendance and appearance of a person released on bail may at time apply to a magistrate to discharge the bond, either wholly or so far as relates to the applicants. On such application we made, the magistrate shall issue his warrant of arrest, directing that the person so released be brought before him. So all or any sureties for the attendance or appearance of person released on bail may at any time apply to a magistrate to discharge the bond, either wholly or so far as they relate to the application. So the magistrate will then issue a warrant to arrest, directing that the person so release be brought before him. So bring back. On the appearance of such person, pursuant to the warrant or on his voluntary surrender, the magistrate shall direct the bond to be discharged either wholly or so far release to the applicant, and shall call upon such person to find other sufficient sureties, and if he fails to do so, may commit him to jail. So the person was out on a bail because the sureties were there. Now all of them or some of the sureties, they for whatever reason, if they come back and make an application to the same court saying that please discharge me of this bond, I don't want to be a party. So either wholly, all of them, or partially, some of them. In that case, if such application is made, the person who has been out, it's similar like the previous one, where it was a deficient for whatever reason, the sureties has become deficient or were recognized being deficient, which went unnoticed. In 489, it is a condition created because some or whole of the sureties want to withdraw from that particular situation and they're seeking a discharge. In that case, again, similarly like the previous section, the person has to be brought back to the magistrate. He has to be rearrested and brought back because the bond has failed. The conditions have failed now. So on appearance, this person can come, or he can also come and surrender also. And then the person has to be informed that what has happened, and then he has to bring in sufficient other sureties in case of to replace the persons who have discharged themselves or make application to discharge. And if he fails to do so, then you please go to the jail, because the bond conditions are not fulfilled. So this is discharge of sureties under 489. The sureties wanted to be discharged. They wanted to be relieved upon from the conditions of being surety, and they say once they are gone, the warranty is gone for the person to be out on the bail. And as it fails, the person has to bring in new surety to continue be outside, or has to go in the jail because there is no surety which is available for him. Section 490 talks about deposit instead of recognizance. So when any person is required by any court or officer to execute a bond or a bail bond, such court or office may expect, in the case of a bond for a good behavior, permit him to deposit a sum of money or government promissory notes to such amount as the court or officer may fix in lieu of executing such bond. So this is basically alternative to the bond execution. So the section basically provides a flexibility to the person by allowing individuals required to execute a bond or bail bond to deposit a specified amount of money or government promissory note, etc. They have to bring in, and this alternative can make it easier for the individual who may struggle to meet bond requirements while still complying with the court order. So this is again second option which is given to them, and for provisions specifically excluding the cases involving bonds for good behavior. This is significant because bonds for good behavior which is relating to ongoing legal obligations regarding conduct and community relation, etc., which may not be appropriately addressed through a mere deposit. So this provision specifically excludes cases including bond for good behavior. So it says any person required by any court or officer to execute a bond or bail bond, such court or officer may accept in the case of bond for good behavior. So in case of bond of good behavior, if something is required, then this is not applicable. Money cannot be replaced or provided as a stand as a bond for a good behavior. So court of officers discretion is definitely fixed here, because the court officer uh, can put his discretion on accepting such kind of deposit instead of a bail bond. So the choice is of the court officer or the court. So this gives an accessible and a convenient way, a flexible alternative for the accused to put a deposit instead of a bail bond, and it brings a flexibility, but it is not a replacement for a bond for good behavior, and it is something which preserves the court's standards for the bail conditions by providing even an alternative to ensure that the bond, if not, the person could also make some deposition of amount, and of course that cannot be unlimited or very unreasonably high. Section 491 says procedure when bond has been forfeited. So we have been talking about in so and so conditions the bond can be forfeited. So what it says is, so subsection 1, 2, 3, 4, and 5. 5 subsections are there. Subsection 1 says where a bond under this Sanghita is for appearance or for production of property before a court, and it is proved to the satisfaction of the court or any court to which the case has subsequently been transferred that the bond has been forfeited, or in respect of any bond under this Sanghita, it is proved to the satisfaction of the court by which the bond was taken, or any court to which the case has been subsequently been transferred, or of the court of any magistrate of the first class that the bond has been forfeited. The court shall record the grounds of such proof and may call upon any person bound by such bond to pay the penalty thereof, or to show cause why it should not be paid. Explanation. A condition in a bond for appearance for production of property before a court shall be constructed as including a condition for appearance, because until and unless you are not appearing, you cannot do that. Or as the case may be, for production of property before any court to which the case may subsequently be transferred. So as we know, the bonds can be committed for the court or the subsequent court also. We just saw that bonds could be a condition for appearance in the High Court, Session Court, and other higher courts also. Subclause 2 says if sufficient cause is not shown and the penalty is not paid, the court may proceed to recover the same as if such penalty were in a fine imposed by it under the Sanghita, and provided that where such penalty is not paid and cannot be recovered in the manner aforesaid, the person so bound as surety shall be liable by order of the court ordering the recovery of the penalty to imprisonment in the civil jail for a term which may extend to 6 months. So the person will go to the jail, provided subsection 3 says the court may, after recording its reason for doing so, remit any portion of the penalty. Though remittance is also a part given as a judicial discretion. Any portion of the penalty mentioned and enforce payment in part only also they can do. Subsection 4 says whereas surety to a bond dies before the bond to be forfeited, his estate shall be discharged from all liability in respect of the bond. So he will not be his state will not be liable anymore. And subsection 5 says wherein a person who has furnished security under section 125, 136, or 401 is convicted of an offense, the commission of which constitutes a breach of the condition of his bond or of a bond except executed in lieu of this bond under section 494, a certified copy of the judgment of the court by which he was convicted of such offense may also be used as evidence in proceeding under this section and under this section against this surety or sureties, and if such certified copy is so used, the court shall presume that such offense was committed by him unless the contrary is proved. So when a person has furnished a security under section 125, we have seen it, I think yesterday. So, for example, security for keeping peace and peace for on conviction. Oh no, we'll do it today. So, any kind of peace, security for keeping peace on conviction, or section 136 or section 144. 136 is order to give security has been done by some or other authority, or section 401, where the order is to release on probation of good conduct after admonition, which is given. So, in those conditions, if the convicted of such offense of commission which constitutes a breach of the condition of his bond, or of a bond executed in lieu of his bond under section 494, certified copy of judgment by which he was convicted of such offense may be used as evidence in proceeding under this section. So that becomes a benchmark, the judgment. And if such certified copy is so used, the court shall presume that such offense was committed by him, unless the contrary is, because it is already proved by those conditions. 494 we'll see shortly. So what it says is conditions to leading to forfeiture. So two scenarios are given in subsection 1, where number 1 says a bond for appearance or production of property is not complied with, and this it is proven to the court's satisfaction and beyond doubt that by the original court or the court that has given up such case later, that the bond has been forfeited. Or for any other type of bond, the same principle applies, with the court needing the to establish that the bond has been forfeited. So any other court, maybe a trial court, etc., etc. The court's authority upon forfeiture is something which is demonstrated in section 491, and it says that the court must record the ground on which the bond is deemed forfeited. So it has to be also documented. Following this, the court may call upon any individual bound by the bond to pay the penalty or explain why it should not be paid. So if the person has to come back and give either or both, mostly it is both. They have to pay the penalty also, and they have to also give a reason. So this provision ensures a due process is established to allow the surety or accused to respond to the claims of forfeiture. So they have to also given an opportunity, although a short opportunity, but it is given. And in case they do not pay and there is a liability to pay a penalty, then it is considered something is a the court can proceed to recover it. It was a fine under this section. It will be automatically converted as status of a fine, which is then a procedural requirement, a technical requirement to pay in that case. And even if that fails, then the surety who is standing as a surety will may face a civil imprisonment for 6 months, which means imprisonment will happen, but then it will be civil in nature and no rigorous imprisonment, etc. will happen. But the person will be uh, ordered to be imprisoned, so that the bail seriousness of the bail conditions are understood. In case of mitigation of a penalty, if it wants, the court, if wants to do by their own discretions, if they want to remit that fully or partially that particular fine to the person, to the surety, if they believe it is okay, they can, on compassionate ground, they can also allow under judicial discretion to remit such kind of penalty on the surety also. In case of a deceased surety who has passed away, who has died, that if the person dies, the surety dies, the bond is considered forfeited, and their state is relieved of any liability, and it protects the family or the state of the deceased from any obligation coming out of such kind of forfeiture of the bond. So it's a very practical implication on accountability of the bonds on the sureties in conditions where it is considered forfeited. It's a timely legal recourse which is given, and the court has to document also what has happened, and they cannot just arbitrarily verbally go ahead and order this. And there is a balance informant also taking care of situations where if a surety is dead. And we have seen in a previous section, instead of becoming non-compliant, a surety can also opt to withdraw in time from that particular matter, and such application can be given. Then, in that case, the particular accused responsibility is then flagged by the law to ensure that the person who is uh, they have to replace with a new surety. Now we have talked about bond, forfeiture of bond, conditions of the bond, the reasonability of the bond. But now let's talk about the cancellation of the bond and the bail bond. So why, without any prejudice to the provisions of section 491, the previous one, where bond or bail bond under this Sanhita is for appearance of person in case, and it is forfeited for breach of condition. So for breach of condition, if it is broken, then it is different condition. Otherwise, the bond executed by such person as well as the bond, if any, executed by one or more of sureties in that case shall stand cancelled. And so subclause B says thereafter no such person shall be released only on his bond. In that case, if the police officer or the court, as the case may be for appearance before whom the bond was executed, is satisfied that there was no sufficient cause for the failure of the persons bound by bond to comply with this condition, provided that is subject to any other provision of the Sanhita, he may be released in that case upon the execution of a fresh personal bond for such sum of money and bond by one or more of such sureties as the police officer or the court, as the case may be, think sufficient. So what it says is automatic cancellation of the bond, which is the condition being talked in 490. It's an automatic cancellation. So it says that when a bond or a bail bond, which is required for the appearance of a person, is forfeited due to breach of condition. So we are not talking about we are without any prejudice to the provisions of the section 491. So what we're talking about is when the bond condition is uh, appearance of a person is forfeited due to breach of the condition. So both the individual's bond and any bond executed by the sureties will automatically be cancelled. So it is broken, it is considered automatically cancelled. And this reinforces the accountability of both the accused and their sureties, ensuring that the compliance of the condition set forth is followed. So any kind of breach condition uh, by by the person where uh, it's a breach condition, the forfeiture will happen is due to breach of condition, then this condition is applicable, will automatically be cancelled. Then subsection 1B says that the once the bond is forfeited, now the bond is forfeited, the individual cannot be released solely on their personal bond. Now they cannot be released solely on a personal bond if the police officer or the court finds that there was no sufficient cause for failure. So if there was no, it is done by will. So if it is done by willingly, if something is done by willingly, the person has violated by will. It's not accidentally something has happened, or it was, say, for example, somebody is asked to stay in a particular city as a bail condition, and he does not stays in that, he is found in some other city where he was not supposed to be allowed to be doing that bail condition. Then this is something which is a condition where is a breach of condition. But what happens if the person had a immediate medical condition and he had to be admitted to the city for some or other reason for a quick treatment? Then it is not something which is considered as a breach of condition. So in that case, this is not something which is done by will. So the once the bond is forfeited, the individual cannot be released on their personal bond or court if there was no sufficient cause for the failure to comply with the bond condition. So if there was no condition, this means that the individual must adhere to the stricter requirement to regain liberty. Now they have to get a stricter liability and reinforcing a seriousness of the compliance of the judicial obligation which is there. So they cannot be released on only a personal bond. And this is an accountability of the sureties which will happen. So this particular section is in addition to section 491, and it is something which is legal privilege under section 491 which is given there. It is something without prejudice to that particular section. And this is an accountability to the sureties also which is given, and it's a judicial oversight in bail decision as well which happens in during this section. And it's a person if he breaches the condition and if he's not able to explain that it was something not done with will, then the person has to be uh, shall be released thereafter. After that one incident, the person cannot be released only on his bond. Then, until and unless he is able to explain that it was not done, the breach has not been done by him for some mischief, and he has complied, but it is something, the failure which has happened because of some reason which was not actually intended to be done. Now we move to section 493, which is procedure in case of insolvency or death of a surety when a bond is forfeited. Now, there might be a condition when you have sureties who are standing for you, and those sureties are insolvent or dead. Dead, we have seen already a part of it where it talks about that when they are dead, there is no obligation on their estate, or when a bond is forfeited. So, what is the procedure in those cases when it becomes insolvent, or a death of surety, or when a bond is forfeited? We have seen the conditions earlier. So, when a surety is to bail bond under the Sanhita becomes insolvent, has no money, or dies, we have seen that, or when a bond is forfeited, we have seen that under 491. The court by whose order such bond was taken, or a magistrate of the first class, may order the person from whom such security was demanded to furnish fresh security in accordance with the direction of the original order, and if such security is not furnished, the court magistrate may proceed as if there had been a default in complying with such original order, and they have to proceed their person to the jail. It's a very simple one, just clubbing. It's a clubbing section which clubs the multiple things at one place, and it is only uh, indicating that in all such conditions, whatever happened, the if the court which was or by whose order such bond was taken, or a magistrate of the first class, they may order a person from whom such security was determined to furnish fresh security, they have to do, or if it is considered not done, then it is considered as a default in complying. The result is always a punishment, and the person would be sent to jail. Let's see section 494 now. So 494 is a special section, and it is applicable in a very special scenarios where there is a requirement of a bond from a child. Hmm. So a lot of people I come across, they have not even heard of this. So a bond sometimes is required from the child also. So when the person required by the court or officer to execute a bond is a child, now the subject to the bond is a person who is a child. Such court or officer may accept in lieu therefore a bond executed by a surety or sureties only. Because how come the expectation could be there for a child to uh, be able to execute a bond with some money? It can only be through sureties because he is anyways a minor. A child is defined in BNS now as a somebody who is up to the age of 18. So the person defined, the definition of the child could be borrowed in BNSS, but naturally from the BNSS, which is somebody who is under the age of 18. The moment they become 18, they become major. So up to a day before 18, the person is a child. And this section talks about acceptance of surety bond from those people who are below 18 years a day before being 18 years. So this allows the court to or officer to accept a bond solely by one or more surety, because the person required to execute the bond is a child, which means that the legal responsibility to ensure that the child adheres to the condition, the child will adheres to the condition, means he will do all those things which is the bail condition, which is primarily in this case would be to him or her to be able to join the trial whenever the person is asked on the dates the person is to come, or ensure their presence to the police for investigation, cooperate, etc. The legal responsibility is put on the shoulder of the people who are major and who act as the surety. So these are the adults who take the guarantee of the child's appearance in form of a surety and in terms of a financial obligation. And what is the objective of this provision? To burden the responsibility of the child's presence on the adults who are connected with him, because this cannot be done directly to the child against the laws of related to the juvenile. So the law itself cannot cross the limits and treat the they have to treat the child as a child as per the law, and it has to be, the burden has to be transferred to the people who are major and who could stand as a surety. This is something which is asking a bond also from a child, but it is also protecting the minor also, that they cannot be expected to be put on a financial obligation. And that is why a window out is given in that case, so that the minors are excluded by only giving the surety of one or two persons. So, for example, say there is a case where a minor is involved in a criminal proceeding somewhere, and the court may require a surety bond to ensure the appearance of the person happens. And any adult family member or any guardian or any such relative with whom he stays act as a surety, that the minor definitely contractually comes into the obligation, and uh, without any uh, direct consent to the person, but through a parental consent, which means if a person is a minor, the consent is made by the family member on his behalf to ensure that he will appear. So basically, this is a something which is ensuring that the minors are not placed in situations beyond their understanding or capacity also. Because in spite of they being part of this kind of criminal activity, they might be in a situation where they don't understand basically what exactly is the surety condition, what is the bail condition, etc., which is not, cannot be considered their capacity, maintaining their right, that while upholding some responsibility for the compliance, their right as a children is also something which is taken care. And the juvenile justice care, the JJ Act, as we say, Juvenile Justice and Care and Protection of Children Act 2015, that also underscores that basically when dealing with the children, and any legal proceeding against them must be respected in any legal proceeding, reaffirming that the principle against placing undue legal burden on the minor has to be taken. So undue legal proceeding pressure cannot be put on the child. For example, in case, for example, somebody uh, custody or care of a minor, court have to upheld that guardian or the legal custodians are responsible for decision impacting the minor's legal obligation. So they are considered they having obligation. And this can extend to the framing of bond and commitment under the law with the parent or the guardian of that particular child. So this is a child's legal and welfare interest which is taken care, which is also something given by the acts like JJ, and the Constitution specifically gives such rights to the children. Now, 494 was a special section, appeals from order under section 491. So all orders passed under section 491 shall be appealable. So in the case of an order made by a magistrate, it can be appealed with a session court, or in the case of an order made by a session court, to the court which an appeal lies from an order made by such court, which is mostly a high court. So it says, basically it talks about section 491 when the bond has been forfeited. So where a bond under the Sanghita is forfeited and it is proved to the satisfaction of the court that it is subsequently been transferred that the bond has been forfeited. And in case of any other bond under the Sanghita, it is proved that the satisfaction of the court by which the bond was taken, to which the case has subsequently been transferred of the court of any magistrate first class, that the bond has been forfeited. So they will consider it as a, it has been forfeited, and it will be considered as a penalty later. So in such cases, what is the next step which will happen? If it is not restored by the accused, it will be cancelled. So in this such cases, when it is considered forfeited, etc., appeal can be lying on the court higher to that, and that the it is appeal right has been given, and nothing but the hierarchy is called under subsection 1 and 2 in this particular section, which talks about where the court is a magistrate, goes to the session, then it goes to higher court, which is the high court. which is again a right which is given to them to give an appeal also, because this is something which is protecting the right of the accused again, that there is no mistake, there is no bias, and a judicial oversight is given in a serious situation like this, because bails are conditions which are considered primary to the judicial system than the punishment. So in that case, a bail is a very serious business. If a bail has been given, taking away that bail condition is a very difficult situation for the courts, and it has to be proved very strongly that the bail has to be taken back from that individual. So for that condition, there is an option to give an appeal also, where the person has to give an appeal on the higher court where the bail is considered forfeited. So this encourages a judicial oversight in such serious situations of bail, where this is a question of a liberty and which is given a primary importance by the Constitution also. So any person's liberty is one of their rights which is secured by the Constitution, and in respect to that right, in the light of the Constitution, it is very, very important that the person is allowed to do that, appeal, make an appeal, which is section 491. Now let's go to section 496, which is power to direct levy on amount due on certain recognizance. So the High Court or the session may direct any magistrate to levy the amount due on a bond for appearance or attendance at such High Court or Court of Session. So this is a power against the subordinate court, what the High Courts can exercise, and they can, this grants the power to them, an authority to direct a magistrate to uh, recover the amount which is owned on the bonds related to a individual's appearance. So that power is given to the High Court or Session Court to operate through the magistrate. So this is an authority given to them, that they can issue directions to the magistrate to take necessary action to recover amounts specified in the bonds, which has to be paid by the sureties or by the accused. So the authority underscores a critical role that the higher courts play in maintaining judicial integrity and compliance with the legal obligation, and use the right judiciary tools as well at the ground level. The focus of this section is on recognizance, which is a formal bond or commitment. Recognizance means a formal bond or a commitment made by the individual to appear before a court. So this is a levy of amount on due to a certain recognizance, and that can be if an individual fails to adhere to these conditions of recognizance, uh, such as appearing in the court, etc., then the amount specified in the bond becomes due, and then High Court and Session can instruct the magistrate to levy that amount and recover it from that person, illustrating the enforcement of the bond and the recovery process. So the procedure of the action is given here in this one single line, where the detailed procedure is not given, but it simply gives a procedure by the High Court and Session Court to engage those courts, which is around which are in their jurisdictions, or which would generally involve assessment and collection process to be followed, helping the High Court and the Session Court. So it ensures a compliance through court order by a higher court to the lower court magistrate, and a judicial authority established with this, and it ensures the bond is effectively collected in case of the bond was the certain recognitions are violated. So any contract and condition it is violated, then it is something which is recovered. So this finishes the chapter 1. Let's move to chapter 2, which is security for keeping peace for good behavior. So section 125 is something which is coming under 125 to 143. What we'll study now is a full section, a full chapter of chapter 9 of BNSS, which is security for keeping the peace and for good behavior. So what could be the security for keeping peace and for good behavior? We talked about the good behavior security. We'll see this in this particular chapter. So the first section in this chapter is section 125, which says security for keeping peace on conviction. So any chapter starts with a base section, which establishes the base guideline for that particular chapter. So 125 is a base guideline for this chapter, which is security to keeping peace on conviction. So section 1 says, subsection 1 says, when a court of session or a court of magistrate of the first class convicts a person of any of the offense specified in subsection 2 or of abetting any such offense and is of opinion that it is necessary to take security from such persons for keeping the peace, the court may, at the time of passing sentence on such person, order him to execute a bond or bail bond for keeping the peace for such period, not exceeding 3 years as it thinks fit. So in such conditions, the court can execute a bond or bail bond. So what are the offenses? The offenses are any offense punishable under chapter 11 of the Bharatiya Nyaya Sanhita other than any offense punishable under subsection 1 of section 193 or section 196 of section or section 197 thereof. B. Any offense which consists or includes assault or using criminal force, committing mischief. So for these cases, any offense of criminal intimidation, okay, and any other offense which caused or was intended or known to be likely to cause a breach of the peace. So when a court of session or magistrate first class convicts a person of any of such offenses, which are subsection 2. So which are the offenses? Any offense punishable under 11, which is offense against the public tranquility, except other than an offense punishable under subsection 1 of section 193, 196, 197 thereof. So 193 is liability of owner, occupier, etc., promoting enmity and imputations. While any offense which consists or include of assault or using criminal force, any offense of criminal intimidation, or any other offense which caused or was intended to know to be likely to cause a breach of the peace. So any of the cases, so of abetting or any such offense. So if the person, any of the offense which is the person is convicted of or of abetting, or if they have abet also, is of opinion that it is necessary to take a surety from such person, then the court may, passing such sentence, person order him to execute a bond also. Subsection 3 says if the conviction is set aside or on appeal or otherwise, the bond or the bail bonds executed shall become void. And an order, because the purpose was to ensure the security for peace and tranquility. And subsection 4 says an order under this section may also be made by an appellate court or by the court when exercising its power of revision. So that is also something we have seen in the previous chapter also when we were talking about it, then that when such kind of bail of appearance for the, when there is a appeal made in a other upper court, then in that case a 6-month bail bond was also given in that case also to appear by in the appellate court, and it could be executed by the lower court or the appellate court both. So in this case, the court can pass such kind of bond or bail bond for keeping peace for such period not exceeding 3 years, which is given in this particular section. So this is an authority of the court to keeping the peace and conviction. They can ask for a bond or a bail bond, which is against the offenses which are listed under subsection 2, and the duration of the security cannot be more than 3 years. And because the punishment for these activities are also not beyond that, and that is why it cannot be more than 3 years. And the effect of appeal and overturning conviction is also, which is given in the subsection herewith, which is subsection 3, that the court can set the duration. Sorry, the conviction is, if is overturned, if the conviction is overturned, is removed, then this condition also becomes void, and whatever bail conditions, for example, financial surety, etc., were put, or the sureties were present, etc., will be sent back. The person can becomes void, and the right is also protected in case of a successful appeal. And the applicability of the order is given by in subsection 4, which says that the order to execute a peace bond. This is a security of keeping a peace on conviction. So this peace bond, whatever peace bond is made, is also made by the appellate court or any court exercising its revisionary power. Any court which is doing a revision also can also have the power to execute a peace bond. So they can also do it. And this is a supervisory role of such kind of higher courts in maintaining the integrity of justice in what is mentioned in the subsection 4. So if we talk about the appellate courts and the courts which have in revision power, so in that case, we are also giving this power to the courts of higher order. So this is something which is a reinforcement. In case of abatement or in case of such kind of conviction, if there is a quite chance that the person, because what is meant by such kind of crime is these kinds of crimes are sometimes political. These kinds of sometimes gang ways, sometimes a group based crime. And if the kingpin or the persons who are part of it, if they are arrested, there is quite a chance that through their people they might again cause such kind of issues which may cause public tranquility. So in interest of persons, in spite of convicting them or punishing them for any kind of abatement, it is sometimes very important to execute a heavy bail bond to them so that they will being inside in the jail when they are convicted, their people are not again causing the same thing, which will cause a forfeiture of their particular bond what they are putting in. It is not more than 3 years because that's the duration of the punishment max in those areas. So this is a judicial oversight and discretion given, seeing the situation about how they have to move, the courts can move, and it brings an accountability on head of the person who is convicted again, that in spite of getting convicted, they cannot still not create a fuss, create a situation in spite of being convicted in these situations. So this is a precautionary measure given to make a peace bond by those people so that they are not creating any issue. They're not disturbing the peace in general in spite of being convicted through their agents. Section 126 talks about the security for keeping peace in other cases. So we talked about specific cases where such kind of uh, people we talked about in case of public tranquility, etc. What about the other cases? So when an executive magistrate, now it's a discretion of an executive magistrate, when executive magistrate receive information that any person is like to commit a breach of the peace or disturb the public tranquility or to do any wrongful act that may probably occasion to a breach of the peace or disturb the public tranquility, and is of opinion that there is a sufficient ground for proceeding, he may, in the manner herewith provided, require such a person to show cause why he should not be ordered to execute a bond or bail bond for keeping the peace for such period not exceeding 1 year as the magistrate thinks fit. And proceedings under this section may be taken before the any executive magistrate when either the place where the breach of the peace or disturbance is apprehended is which is local jurisdiction, or there is within such jurisdiction a person who is likely to commit a breach of this peace, disturb the public tranquility, or to do any wrongful act as aforesaid beyond such jurisdiction. So basically, this is an authority of an executive magistrate specifically, which is given under this section of BNSS. Collector, SDM, etc. So this is a administrative situation where these people are committing uh, a person is going to commit a breach of the peace or disturb the public tranquility because of his activities. So in this case, it gives an authority to the executive magistrate to come back and show cause that person that this is what you're doing, this is what is going to harm the public peace and order. Why shouldn't we execute an bail bond order? We order to do that so that the peace for this period, so and so period, is kept preserved. And but this cannot be done for more than 1 year, and this requirement for show cause can be issued. And the jurisdiction is given in subsection 2, which says the proceeding under this can be initiated by any executive magistrate whose jurisdiction encompass either the location where the breach of the peace is anticipated or where the individual likely to commit such act reside. So either the magistrate where it is already done or where the magistrate believes that in his jurisdiction it will happen. So where it is already executed or it is going to be executed, both the sides executive magistrates can have the jurisdiction in this case. And this provision ensures that the judicial oversight and coverage is extended in terms of a precautionary measure also. This is a proactive legal measure which is given to the executive magistrates. Whenever the legal provisions are there for the exec magistrates, this is mostly from the proactive perspective or creating the order perspective. And judicial discretion and accountability is given in that sense to them. And a flexibility is given that not only on the situation where such something has already happened, they have to go and act. They can also act on the situation where they believe it will happen. So both the side magistrates have a jurisdiction to go ahead and issue such a show cause notice or surety, issue such as surety or a bond for keeping the peace from such person. And it can be done up to maximum of 1 year as the magistrate thinks fit. That duration can be put under such amount. Section 127, it talks about security for good behavior from persons disseminating certain matters. So this is something for good behavior we have been talking about. So subsection 1 says, when an executive magistrate receives information that there is within his local jurisdiction any person who, within or without such jurisdiction, number one, either orally or in writing or in any other manner, intentionally disseminates or attempts to disseminate or abets the dissemination of any matter the publication of which is punishable under section 152 or section 196, 197 or 299 of Bharatiya Nyaya Sanhita, any matter concerning a judge acting or purporting to act in discharging of his official duty which amounts to criminal intimidation or defamation under the Bharatiya Nyaya Sanhita, or clause 2 makes, produce, publishes or keeps for sale, import, export, conveys, sells, let to hire, distributes, publicly exhibits or in any other manner puts in circulation any obscene matter such as referred into section 294 of BNS, and the magistrate is of opinion that there is sufficient ground for proceeding, the magistrate in the matter hereinafter provided requires such person to show cause why he should not be ordered to execute a bond or bail bond for his good behavior for such period, not exceeding 1 year as the magistrate thinks fit. So previous sections were of bond of peace. This is for a bond of good behavior. So that is the difference, first of all, between the previous section and this particular section. Now, it says when the executive magistrate receive an information that there is a, within his local jurisdiction, any person who, within or without such jurisdiction, so whoever has got that jurisdiction being to be in that particular part or who is not from that jurisdiction is in his jurisdiction at the point of time, who is either orally or in writing or in any other manner intentionally trying to disseminate or attempt to disseminate or abet the dissemination any matter which is against the sovereignty, unity and integrity of the India, which is section 152, or any matter which is to defame, criminally intimate or defame any of the judge acting upon or purporting act in the discharge of this official duty, make, produce, publish or keep anything which is obscene, that magistrate can put a show cause to ask why I should not put a show cause to you and why you should not be ordered to execute a bond. Subsection 2 says no proceeding shall be taken under this section against the editor, proprietor, printer or publisher of any publication registered under and edited, printed and published in conformity with the rule laid down in the Press and Registration of Book Act with reference to any matter contained in such publication except by the law order or under the authority of the state government or some officer empowered by the state government in his behalf, which means anything which is an unregistered business, which is definitely then having no control established as required by the central and the state government and which is operating illegally, then in those cases they can operate. Otherwise, we have seen it in the previous chapters also, in those situations where this kind of books and publication has to be banned. It always starts from the initiation from the state government or some authority which is allowed to act on behalf of the state government. So section 127 is an authority again of an executive magistrate which is where when they receive such an information, credible information, where the about some individual within their jurisdiction who is standing within their jurisdiction, who is transmitting or attempting to transmit specific information, specific harmful material. He is transmitting. Uh, he's trying to disseminate. He's transmitting such materials uh, to specific harmful material, which is giving this right to protect the public interest. The magistrate can act. Now, it can be several types of things which can be done by orally writing or any other matter in either way program, for example, orally over microphone, without microphone, writing, or through recorded or through broadcasted. Anyway, the person is doing it. The act of dissemination is also defined here, where it says, which is something which is related to integrity of the nation, unity of the nation, which is something intentional crime, which is about a judge which could be deemed a criminal intimidation and defamation, where the purporting his act on discharge of his official duty and producing disturbing obscene material also in all those cases this act of dissemination is considered. And uh, there is a requirement of show cause like the previous sections, which could be issued by the particular executive magistrate, and the period for which the bond is required by the magistrate cannot exceed 1 year in this also. And this allows the magistrate to impose conditions that are relevant to the relevant threat. To whatever perceived threat will is there, according to that, they can put a condition. And only the registered publications cannot be subject of this section, because there is a separate procedure and section for that, where the registered books and publication comes under the effect, and that is only through the authority of the state government or some officer empowered by the state government. So this is a preventive justice again. This is a preventive power also given to the magistrate, and this is a protection again given to the legitimate publishers, but it is to the illegitimate publishers. It is something which is applicable to. Section 128 talks about security for good behavior from suspected persons. So when again, this is an power to executive magistrate who receives when information that there is a within his local jurisdiction, always in a local jurisdiction, a person taking precautions to conceal his presence. And there is a reason to believe that he is doing so with a view to committing a cognizable offense. So he is hiding there to commit some cognizable offense. The magistrate may, in the manner hereinafter provided, require such person to show cause why he should not be ordered to execute a bond or a bail bond for his good behavior for such period, not exceeding 1 year, as the magistrate thinks fit. So this is again a power to the executive magistrate, where if the person who are deliberately hiding in their presence and potentially in preparation for committing some kind of cognizable offense, this authority allows magistrate to take preemptive actions to ensure public safety. And the grounds for action could be, the section stipulates that the reasonable grounds has to be there, could be believed, and that the person is actually trying to conceal their identity with intent to committing such kind of cognizable offenses. So this will something which ensures a preventive preventive action with a sufficient evidence and reasonable suspicion to balance a public safety. So this is a requirement to show cause, which has to be again given first by the magistrate, and in case the bond has to be executed, it has to be up to 1 year with the conditions the magistrate thinks fit. So this is again a preventive measure which is shown by the section 128. Now section 129 of BNSS. Okay. Security for good behavior from habitual offenders. So it was for first of all, we talked about the person from uh, uh, the previous to this, we talked about the person who was suspected person. Now this is for habitual offenders. Now we know the person is habitual. So when an executive magistrate receives information that there is with his local jurisdiction a person who is by habit a robber, housebreaker, thief, or a forger, or is by habit a receiver of stolen property, knowing the same to have been stolen, or habitually protects or harbors thief, or aids in the concealment of disposal of stolen property, or habitually commits or attempt to commit or abets the commission of the offenses of kidnapping, abduction, extortion, cheating or mischief, or even the offense punishable under Section 10 of the Bharatiya Nyaya Samhita, or under Section 178, 179, 180 of the or Section 180 of the Samhita, or habitually commits or attempts to commit or abets the commission of offenses involving a breach of peace, habitually commits or attempt to commit or abets the commission of any offense under so and so acts, any offense punishable under any other law providing for prevention of hoarding or profiteering or adulteration of food or drug or of corruption, or is of desperate and dangerous as to render his being at large without security hazard to the community, such magistrate may matter hereinafter provide such required persons to show cause why he should not be ordered to execute a bail bond for his good behavior for such period, not executing exceeding 3 years, as the magistrate thinks fit. So this is again for a good behavior which is to be given. When we say good behavior, what does it mean? They will not show cause those kind of behavior for which they are suspected they have been doing it. So, for example, robbery, or they will show a good behavior of not doing robbery. They will show a good behavior of not receiving the stolen property. They will not act that way, or they will show a good behavior of not habitually harboring the criminals, running the gang. They are not having some kind of activity which is committing some kind of offense of kidnapping, cheating, etc. They will not do that, which is under chapter 10, or they are not something which they are not doing something again in within definitions of section 178, 79, 80, and 81, which is something offenses related to the coins and currencies and the possession of such instruments which is required to manufacture such articles, or who are habitually committing attempt of abet committed offense for any of such crime. For example, related to drugs and cosmetic, Foreigners Act, they are helping the foreigners to hide in the country or making spurious drugs and cosmetics, or employee provident fund related, any kind of provident fund related crime, any essential commodity at hoarding they are not doing, protection of any civil right of people, they are not misbehaving, they are not somebody who is doing something related to customs crime or anything related to food and safety, or any kind of profiteering, adulteration of food, etc., where they are holding the essential item to sell it for the later for a higher price, or this is something which is dangerous and which is security hazard to people. They might be keeping things which might be radioactive, etc., etc. So all those things are coming under this. Now, if you see a wider perspective for this kind of sections, this is why this is given to executive magistrate, because this is in general something which is coming under the in general administration of the particular district, and that is where these are kept under the powers of the executive magistrate. So this is again an authority of executive magistrate to a preventive measures to ensure such things whenever these are highlighted to such executive magistrate, that either of the whatever things is mentioned here is about to happen, they can immediately try to put a preventive action, because preventive, as in say, that prevention is better than cure. Before the crime happens, if we are able to prevent that and we are able to reprimand those people that yes, we are watching you, those crimes are prevented for such people who are very much probable to do it, and we have done it. But there are not enough reasonable reasons where the police can come back and make an arrest to them, and there is not a crime which has acted by them now at this point of time, but they are people who might do this. In that situation, a preventive step is taken on a very wider perspective with section 129, with a in a disguise of showing a good habit. It reprimands them to stay away from the activities what they could go ahead and do that, and they have to, in case of a heightened risk of such people committing that, such information coming to the credible information coming to the executive magistrate. In that case, probably sometimes this comes from the local intelligence, the detection branch, etc., to police also. So in those cases, when the administration is notified, then these kind of activities happen. Those people are brought, they are reprimanded, they are asked to then go ahead and given a show cause notice, and the magistrate can issue a bail bond depending upon whatever the maximum period of 3 years, and such bond can be issued depending upon the conditions the magistrate feels it's good for. And this is basically, in that case, what it is. It is a community protection. It's a preventive community protection which is enabled by BNSS through section 129, and definitely a judicial review is given because it's given to the executive magistrate, and it's a tailored measure which is given to ensure a wide umbrella protection is given for the protection of the society, to put a full stop or try to curb any such criminal to proceed further before even they plan to do it, or if they are planning to do it, such indications are received. Section 130 talks about the order to be made. So when a magistrate acting under 126 to 127, section 128 or section 129, whatever sections where the magistrates were mentioned there, deems it necessary to require any person to show cause under such section. We're talking about show cause. He shall make an order in writing, setting forth the substance of the information received, the amount of the bond to be executed, the term for which it has to be forced, and the number of the sureties after considering the sufficiency and fitness of the sureties. So this person, magistrate, can make an order, and this magistrate under these sections deems it necessary to require any person to show cause, whomsoever he is feeling fit under the previous section to show cause, can make an order in writing. He can make an order in writing that setting forth what is the substance of the information received. No need to disclose the source of the information. That is again protected by certain laws. So setting forth the substance of the information. So what reason, the amount of the bond to be executed, what is the amount to you have to execute, and for the term what it has to be executed and be in force, and the number of sureties after considering the sufficiency or the fitness of this. So what sureties the person is presenting in show cause, after show cause when he is asked to present sureties, those sureties have to be validated similarly as it has been done in earlier. And this is something which is mandated the magistrate to decide if it is necessary. He can show cause these people and he can content of the order has to be so and so. So these are the basic ingredients of that particular order. That is the substance, amount, duration, and number of sureties. The sureties has to be validated before issuing of the order, as we discussed earlier. So it's a transparency of the judicial process where even the person who is a habitual offender or who is somebody who is a troublemaker, in that case also, still we are following to the teeth the judicial process, and the person is given the right details about for which he is being penalized. And it's a structural legal framework given, and protection for the individual is also there, because then it is also accounted for under which reasons that person has been signing a bail bond or providing a surety. Procedure in respect of person present in the court, which is section 131. So if the person in respect of whom such order is made is present in a court, it shall be read over to him, or if he so desires, the substance thereof shall be explained to him. It's like a very general procedure we have talked about in any of the cases where the warrant, summon, everything, even warrant, the content has to be read to the person and it has to be explained. So it is mandate that the individual to whom the order pertain is present, is in the courtroom, the order must be read out loud to him and ensure that the individual is fully aware that the decision being made regarding their obligation and right is done with a promoting transparency and the judicial process. It is an explanation to the order, which is also the individual prefer. They may request that the substance of the order has to be explained instead of being read verbatim. So if they want, there is an option, or if he so desires, substance thereof should be explained to him. So it's not only the reading black and white the order to him. The person could also be asked to uh, go ahead and if he requests to be explained as well. So this provision acknowledge that some people might have difficulty in understanding the legal language also, or maybe the short language also, or the very technical language also. So that is also taken care that the person is completely understanding what is being done against him. Why this is being done? Because everybody has a right to protect themselves, and that is the right is only applicable, or the right is only operable if the person knows what is happening against him. So that is something will give him the right understanding on what is happening against him, and unnecessary fear will not be inculcated, or a situation of uncertainty will not be created. So it is definitely the person has to understand, has to be made to understand. So this is the transparency and fairness what we have in the Indian judicial system, which is reflecting the section 131. And this still empowers the accused in spite of being an accused. of that situation. Now, summons and warrants in case of person not so present. So we'll borrow our idea of the summon and warrant from whatever we have studied earlier, and applying that in the mind, let's read this section which talks about if such person is not present in the court, the magistrate shall issue a summon requiring him to appear, or when such person is in custody, a warrant directing the officer in whose custody is to bring him before the court. So if he's in some kind of custody, that person, maybe because of his being an history sheeter or whatever it is, the person is in some kind of custody for some reason at that point of time, or the person has not come. In that case, the magistrate may issue a summon requiring you to appear, and we know the magistrate can decide to uh, the the person can decide to uh, the court can decide to, magistrate can decide to, instead of summon, can decide to raise an warrant also. So provided that where it is appears such magistrate upon the report of a police officer or upon other information, the substance of which report information shall be recorded by the magistrate, that there is reason for fear of commission of breach of the peace, and the such breach of the peace cannot be prevented otherwise than by the immediate arrest of such person, the magistrate may at any time issue a warrant for his arrest. So that magistrate has called that person, has given a show cause notice, the person has not presented himself in front of the magistrate. In that case, it is quite possible that the magistrate who has summoned him or has asked him to be presented by warrant, and in case of summon, if the person, whenever it appears to the magistrate through the report that there is an immediate risk of violation by the person of the law, then an arrest warrant can also be issued by the magistrate, and that is something which is given in section 132, which is a power to issue a summon or warrant in case as the court deems fit. In case summon, when the court wants him; in case warrant, if he is in custody, or it is believed by the magistrate that it is quite a chance that person who is required in the court might, instead of coming, might breach the peace, and such crime can happen. So then a warrant for an immediate arrest can also be issued. So this is something which is again in addition to the preventive measure which is given by such provisions, which is empowerment given to the magistrates and the executive magistrates. This is an immediate power also given to the court to ensure the court attendance also, because what is the benefit of taking such a preventive measure and putting a show cause notice if the person, even after getting a show cause notice, is at large? He's not presenting himself, or he's, instead of presenting, trying to breach the conditions for which he is being summoned. So in that case, there should be a power given in that case also, and that is what is the power is section 132. Section 133 talks about copy to order or accompany summon or warrant. So every summon or warrant issued under section 132 shall be accompanied by a copy of order made under section 130, and such copy shall be delivered by the officer serving or executing such summons or warrant to the person served with or arrested under the same. So basically, it is a requirement of accompanying a copy of the order. What was the ingredient of the order? Everything, whatever is related to that particular situation arising and why the person is show caused, is given in that order. So this is mandating that any summon or warrant which is giving has to accompany the order, and that is mandated by this section, and this is for the delivery of the copy which has to be given. So this gives a fairness and transparency. The person also has a fair understanding by reading that also, that okay, I have to definitely be there because the summon is something about very serious and I understand what it is about. Or if a warrant is given, the person knows very well then why he has been arrested and brought to that particular court. So this follows the principles of fairness and transparency across in BNSS in all the areas we have been seen. And this is something which is taking care of the right of information to the person, right of the equality in front of the eyes of the law is also, which is established by this particular section. And this is a transparency which is continued through this section. Section 134, power to dispense with personal attendance. Now, the magistrate may, if he sees sufficient cause, dispense with the personal attendance of any person called upon to show cause why he should not be ordered to execute a bond for keeping the peace or for good behavior, and may permit him to appear by an advocate. So magistrate, if see sufficient cause, allow the person, discretion can be given to the magistrate that okay, uh, if there is a sufficient cause, uh, the person can be appear through an advocate also. So the if sufficient cause which is believed by the magistrate, and he can be allowed to be absent also in person, no requirement for the person to come uh, in person. For example, many reasons. For example, the person's health issues, he's in a hospital, or logistical challenges to bring that person, or maybe some kind of security or mob reasons. The person, if comes, there might be a mob which might come, or any other such valid reasons, and the court can ask the person to be represented by a advocate itself. So this is something which is a practical flexibility which is given in such conditions where it is required, and it is also something which is streamlining the court process if such situation arises. So it is also thought of and accommodated by the law. Section 135, which talks about the inquiry as to truth of the information. So when an order under section 130 has been read or explained under section 131, we talked about reading and explaining to the person present in the court, or when any person appears or is brought before a magistrate in compliance with it, or in execution of summon warrant as 132. The person has been given summon, or a warrant is issued when he is in custody, or a warrant is issued if there is a threat that person, imminent threat, the person will commit some crime. The magistrate shall proceed to inquire into the truth of the information upon which action has been taken, and to take such further evidences as may appear necessary. Such inquiry shall be made as nearly as may be practicable in the manner hereinafter prescribed for conducting trial and recording evidence in summon cases. While subsection 3 says after the commencement and before the completion of the inquiry under subsection 1, the magistrate, if he considers that immediate measures are necessary for the prevention of a breach of the peace, of disturbance of the public tranquility of the commission, of any offence for the public safety, may for reason recorded in writing direct the person respect to whom the order 130 has been made to execute a bond, bail bond, for keeping the peace or maintaining good behavior until the conclusion of the inquiry, may detain him in custody until such bond is executed in default of execution until the inquiry is concluded, provided that no person against whom proceedings are not being taken under section 127, 128, 129 shall be directed to execute a bond or bail bond for maintaining good behavior. So the conditions for such bond, whether as to the amount thereof or as to provisions of sureties of the number thereof, the pecuniary extent of their liability shall not be more onerous than on those specified in the under section 130. And for the purpose of this section, the fact that a person is habitual offender or is so desperate and dangerous as to render his being at large without security hazard to the community may be proved by evidence of general repute or otherwise. Where two or more persons have been associated together in the matter under inquiry, they may be dealt with the same or separate inquiries as the magistrate shall think fit. The inquiry under this section shall be completed with a period of 6 months from the date of the commencement, and if such inquiry is not so completed, the proceeding under chapter shall, on the expiry of such period, stand terminated unless for special reasons to be recorded in writing by the magistrate. Otherwise directs, provided that where any person has been kept in detention pending such inquiry, the proceeding against the person, unless terminated earlier, shall stand terminated on the expiry of the 6 month of such detention, and where any direction is made under subsection 6 and permitting the continuation of proceeding, the session judge may, on an application made to him by aggrieved party, vacate such direction if he is satisfied that it was not based on special reason and was preserved. So what is it says? So it says that inquiry into the truth of the information. So the magistrate receives multiple information, and once an order is read or explained to the individual, or when the person present themselves following a summon or warrant, the magistrate is required to investigate the truth of the information. So they have to first of all ascertain the truth that prompted the legal action. So they have to first inquire upon why this particular information has come, what is the truth, what is the weightage of that particular information, and this emphasizes the need to due diligence in the judicial proceeding. So they just cannot go on the beliefs which is ascertained by some kind of information coming. It has to be validated first. Then he talks about conducting an inquiry. So the inquiry should be conducted in a manner similar to how trials are held, but in a summons case way, which is the short way. And we always know the executive magistrates are always running, or the junior courts are always running the trials in summon case way. So this establishes a formal structure for the inquiry, ensuring that it follows the legal protocol. So it is automatically conducting an inquiry, but it is doing in a summon case way, and evidences, etc., has to be recorded. So it gives a inquiry structure also through this particular subsection 1. Now it says it has to be done immediately, subsection 2. So if during the inquiry, the magistrate is believing that an urgent action is necessary to prevent a breach of peace, etc., they must direct the concerned person to execute a bond of good behavior pending the inquiry conclusion if they are doing that inquiry of truth, or the magistrate may document the reason for the decision also in that, and the individual may be detained until they are complying with the bond. So if they are signing the bond, if they are complying, fine. Otherwise, they have to be detained until the inquiry happens or until they comply. However, there is a clear limitation given to not facing proceeding under 127, 128, 129 cannot be compelled to execute such bonds. And these conditions which are attached to the bond must not be stricter than those initially specified in the section 130 order. So it cannot be beyond that, and it is not applicable to section 127, 128, and 129, which is some people who are have to give something related to publication information, or some suspected people who are there, or some people who are habitual offenders. So these people cannot be compelled to execute such bonds, and proof of habitual offenders will be that if somebody is called as a habitual offender and such kind of information has come, then the person's being habitual offender has to be ascertained through the general reputation, other means contributing to the decision of the security and bond. So by people noticing, by the kind of people coming and making an evidence against him, such incidents have been brought forward to the court, and those things has to be ascertained before a person has to be put a status of a habitual offender or to being dangerous. And if there are multiple persons involved, in that case, in that kind of inquiry, the magistrate has a discretion in determining whether to handle their case together or he wants to handle it separately. So that is also a power given under this section, which promotes a fairness based on the circumstances. And timeline for such inquiry is also given in this particular section, which is talking about the time frame, which is the inquiry must be completed in 6 months from the date commences. So if the inquiry is not concluded within 6 months, the person, so the inquiry will be terminated, unless and unless the magistrate will put a reason why it should not be terminated within 6 months, because this is something which is related to a timely justice also, and this is a preventive measure also. And if an individual is to detain pending inquiry, an inquiry is not concluded 6 months, the person will be released. And also in the case where the magistrate has given a reason of extension beyond 6 months, if the aggrieved party can go to the session court, and if the session court believes the reasons are not right as given by the magistrate, the order can be vacated also. The person could be released before 6 months also. So this is something which is related to inquiry as to truth of information of ascertaining that person and trying that person in a summons way, where the right evidences has to be taken, the right precautions has to be taken, that the person, one side the public safety is secured, other side the person is not somebody who is detained unnecessarily, and so on and so forth. Order to be given security, which is section 136. So if upon such inquiry, now inquiry was being done, that so and so person is a risk, blah blah blah, and such bonds have been executed, etc., etc., whatever in section 135 we just saw. So if upon such inquiry it is proved that it is necessary for keeping the peace and maintaining good behavior, as the case may be, that the person in respect to whom the inquiry is made, or the persons to whom in case the inquiry is made, should execute a bond or bail bond, the magistrates have made an order according. So in case the inquiry is happening and that person is proved that that person might be a risk to the peace, and the person in respect to whom this inquiry is being made has to make a bond. provided that no person shall be ordered to give security of a nature different from or an amount larger than for a period longer than the specified in the order made under section 130, and the amount of every bond or bail bond shall be fixed with due regard to the circumstances of the case and shall not excessive. And when the person in respect of whom the inquiry is made is a child, the bond shall be executed only by the sureties that we know very well. So basically, this section 136 talks about necessity for the security when it happens, and when it is necessitated to provide such peace or good behavior bond has to be executed. The nature and the amount of the security is one something which has to be taken in care, where no individual shall be required to give a type of security which is different from 130 in any way, and the duration which is different than anything from section 130. Consideration of the circumstances has to be also done, so that the subjectively the person, the justice is done, and special provision for minor, as we know, to avoid any vulnerability to the minor and accounting from their limited liability, the measures are given for them also to be represented by majors. So let's move to section 137. Discharge of person informed against. So good news about the person. So if on an inquiry under 135, it is not proved that it is necessary for keeping the peace or maintaining good behavior, as the case may be, that the person in respect of whom the inquiry is made should execute a bond. Previous one was, if he can, he should execute the bond. The magistrate shall make an entry on the record of that effect. So they have to make an entry. And if such person is in custody, for example, he was kept in custody for the purpose of inquiry, not for any other offense. So is in custody for this particular inquiry, shall be released, or if such person is not in custody, shall discharge him. Means he is now made clean out of any of such allegations which was put against him. So this is an outcome of the inquiry which is discussed in 137, which is positive from the perspective of the person against whom the accusations has been put, and it has to be recorded with all the reasons why it is believed that way. And depending upon the individual custody status, if the person is solely for the purpose of this inquiry, if the person is in the custody, the person will be released, freed. And if the person is not in custody, the person will be discharged, which means any other further proceeding related to the inquiry will be shut down. It will be finished, stopped, and the action, the individual has the right to be free from the judicial restrictions for this particular subject, and no substantial evidence against them is found. So this is clearly establishing a personal right of the professional judicial oversight and efficiency of the legal procedure to ensure the person who is not somebody who is guilty is freed of his this particular uh, in accusations against him. Section 138 talks about commencement of period for which security is required. So if any person of whom or an order requiring security is made under 125 or 136 is at the time such order is made sentenced or undergoing a sentence of imprisonment already, the period of which is such security is required shall commence on the expiration of such sentence. In other case, such period shall commence on the date of such order unless the magistrate for sufficient reason fixes the later date. So this is a security period for imprisoned individual, the person who is already imprisoned, and then such order is issued. So he's already sentenced, is undergoing a sentence and issued under 125 or 136. The period for which they are required to provide security will start only after their imprisonment has concluded. This provision ensures that the individual who currently serving time do not simultaneously have to manage the obligation of the security order while being arrested or imprisoned. So commencement of security period for this particular section in 138(2) says that for all other individuals not currently imprisoned, the period of security shall begin on the date of security order is made. And this practice ensures that they are immediately accountable for complying with the terms of the security order, and the magistrate has the discretion to fix a later date for the commencement of the this period if sufficient reason exists. So this is three things which is given. One, in case the person is already imprisoned, he is already locked somewhere. In that case, the person has to be uh, understanding that such a period of security will start after their current imprisonment period is completed. Why this is given? The reason is this is all, if you understand, is something which is a security for a preventive matter. So there's all reason it might be something which is desired to be put when the person is freed, and then he might be a cause of worry for the administration. And in other cases, the person by default, the security starts from the day of order, but magistrate can, with his discretion, start it after few days also, and few months also. So it can be something based on the reason. The flexibility is given that they can start this particular commencement of the period can also be considered by the magistrate after later period than the date when it was this particular was ordered. This particular security order was generated. Section 139 talks about contents of the bond. So the bond or the bail bond to be executed by any such person shall bind him. Now, when the bond is executed, to keep the peace or to be good behavior, as the case may be, and in their later case, the commission or attempt of commit in abatement of any offense punishable. When you have made a promise under a contract, imprisonment will be happening, and whether it may be committed in breach of bond or bail bond. So either way, whatever you breach, if you have undergone a contract with administration with the magistrate that I will follow to keep the peace or I will follow to keep the good behavior. If you breach that, the imprisonment is the only option which happens in such kind of failures of such kind of situations. Section 140 talks about power to reject sureties. So subsection 1 says a magistrate may refuse to accept any surety offered. So you are required to send you. We know that there are due diligence and verification and eligibility of that particular surety is also done. So magistrate then certainly has a power to refuse to accept any security offered, any surety previously accepted by him or his predecessor under this chapter on the ground that such surety is unfit person for the purpose of the bail bond. Provided that before so refusing the accept or rejecting any such surety, he shall either himself hold an inquiry on oath into the fitness of the surety or cause such inquiry to be held on report made by a magistrate subordinate to him. Because this is the how he does the verification. The verification of the surety is how it is done. It is done by uh, his own inquiry, or sometimes he gets it done through the subordinate magistrate. So that is why, so before refusing, he can again, this is the same inquiry which is making this happen. Subsection 2 says such magistrate shall, before holding the inquiry, give reasonable notice to the surety and to the person by whom the surety was offered, and shall, in making the inquiry, record the substance of the evidence adduced before him. So why this person is called an unreasonable, and such kind of notice has to be offered, issued. And subsection 3 says if the magistrate is satisfied after considering the evidence so adduced, either before him or before a magistrate deputed under subsection 1, and the report of such magistrate that, if any, the surety is an unfit person for the purpose of the bail bond, he shall make an order refusing to accept or rejecting, as the case may be, such surety and recording his reasons for so doing so, provided that before making an order rejecting surety who has previously been accepted, the magistrate shall issue his summon or warrant as he thinks fit and cause the person for whom the surety is bound to appear or to be brought before him. Now, last part first, when you see the last three lines of this section, of course, in case of the surety is being rejected, what will happen? The person has provided a surety for his freedom. If the surety itself is not a valid one, in that case, what will happen? The person has to be brought in front of the magistrate for sure. So the section says it is an authority to reject the surety, which is very well with the magistrate, because if there is an power to accept and investigate, validate, rejection can also be an option, natural option. So they can reject. Then an inquiry has to be done by himself, the magistrate, or through a subordinate magistrate. And meanwhile, a notice has to be given to the interested parties, including the person who has brought that surety. And recording of evidence has to be done to understand formal understanding about the rejection of the particular surety if he was also somebody who was accepted earlier, and if it is not accepted now. And if after considering everything, it is found that it is unfit, then the magistrate can put an order saying this particular surety rejected, and document the reason also why he is rejected. So this is where the magistrate is also accountable for their choice and maintain a transparency in the judicial process. And in case previously accepted surety is being rejected, the magistrate must issue a summon or warrant to bring the principal individual then to bring, because the previously issued surety is there means the surety is operational for his release. If the surety is no more operational for his release, the person has to be brought back through a warrant. So it brings a ensures a responsible sureties are there. They are being rejected also. If the rejections are done, the rejections are done also with a due process of investigation and not being just like that. And a fair hearing to the surety is also given that why he or she should not be the surety. And in case it is doesn't, the right evidences in place, and it has to be done through a writing reasons by the particular magistrate. And this gives an judicial enhanced accountability also on part of the magistrate. And of course, if the surety which was already accepted and is not being accepted now, which means the person was released using that surety, the person has to be brought back to the magistrate. A custody has to be sought back and presented in front of the magistrate. So this is automatically which happens when the existing surety is rejected. Imprisonment in default of the security, which is something but natural. But let's see section 141. So 141 section says A, if a person ordered to give security under section 125, 136 does not give such security. So he is not giving the security on or before the date, because it has to be given, but it has to be given within the period where it has to be given. It cannot be given at any point of time when they wish to. So on which the period for which security is given commences. He shall accept in the case next herein after mentioned. So whatever we discuss next, be committed to prison, or if he is already in prison, be detained in prison until such period expires, or until within such period is given, he gives the security to the court or magistrate who made the order requiring it. So in either of the cases, he will be detained in the jail until the period of this particular security, or if he's in prison, he will detain in the prison until such prison expires, such period expires, and until within such period he gives the security. So whatever condition court is happy to align with. And subsection subclause B says, if any person after having executed a bond or bail bond for keeping the peace in pursuance of an order of a magistrate under 136 is proved to be to the satisfaction to magistrate or his succession in office. So it's not only that magistrate, it is applicable to the succession in office also automatically. We have seen that in a previous chapter in BNSS or CRPC, to have committed breach of the bond or bail bond. So if the person has committed a bail bond or breach of bond later, and that is something which is observed even by the successor in the office of that magistrate. Such magistrate or successor in office may, after recording the ground of such proof, order that the person be arrested and detained in the prison until the expiry. So again, the person has to be in the jail, and such order shall be without prejudice to any other punishment or forfeiture to which the said person may be liable in accordance with the law. So it is not interfering with that. Subsection 2 says, when such person has been ordered by a magistrate to give security for a period exceeding 1 year, such magistrate shall, if such person does not give such security, as aforesaid, issue a warrant directing him to be detained in prison, pending the order of the session judge, and the proceeding shall be laid as soon as conveniently may be before such court. So, if an order for more than 1 year is given, and such magistrate, if the person is not given, if the such person does not give such security as mentioned, and issue a warrant to bring him, to imprison him, and until the order of the session court will come, probably as the vacating that order or whatever, overturning that order. Subsection 3 says, such court, after examining such proceedings and requiring from the magistrate any further information or evidence which it thinks necessary and after giving the concerned person a reasonable opportunity of being heard, may pass such order on the case as it thinks fit. So after such court, after examining such proceedings, so the court will examine such proceeding, that why the person has not given security, what could be the reason, and requiring from the magistrate any further information through a sub magistrate subordinate to him, which they think fit and necessary. The concerned person a reasonable opportunity is also given to defend himself, may pass such order on the case which they might be fit, provided that the period for which any person is imprisoned for failure to give security shall not exceed 3 years. So any person for the period for the any person who is imprisoned for failure to provide security cannot be more than 3 years. Number 4 says if security has been required in the course of the same proceeding from two or more persons, in respect of any one of whom the proceedings are referred to the session judge under subsection 2, such reference shall also include the case of any other of such persons who has been ordered to give security, and the provisions of the subsection 2 and 3 shall involve that even apply to the case of such other person also automatically, except that the period for which he may be imprisoned and shall not exceed the period for which he was ordered to give security. So it automatically applies to proceedings of the other persons automatically to give a uh, similar treatment to the other person, and which is called the rule of parity. Subsection 5 says a session judge may, in his direct discretion, transfer any proceeding laid before him under subsection 2 or subsection 4 to an additional session judge, and upon such transfer, the additional session judge may exercise the power of session judge, which is part of the session judge power, additional session judge power that we know. Subsection 6 talks about if the security is tendered to the officer in charge of the jail, he shall forthwith refer the matter to the court of magistrate who made the order and shall await the orders of such court or magistrate. So the security tendered to the officer in the jail officer, he will forthwith refer the matter to the court or magistrate who made the order and shall await the order of the court or magistrate. So basically the jail will comply. Subsection 7 says imprisonment for failure of giving security for keeping the peace shall be simple. It will be simple imprisonment, not the rigorous one. And number 8, imprisonment for failure to give. So simple imprisonment is the person is locked inside, but is not allowed to, is not mandatorily have to go back and put some bodily effort every day working in the jail. Subsection 8 says imprisonment for failure to give security for good behavior shall, where the proceedings have been taken under section 127 is simple, and where the proceedings have been taken under section 128 or 129 be rigorous or simple as the court or magistrate in each case directs. So that is the discretion of the magistrate. So this is a consequence of failing to provide security, which we discussed. The straightaway consequence is imprisonment in case of such kind of failures or breach of bond. And provision for extended security period is also given there. In case it is more than 1 year, the person who has to detain in the prison until a order in the other way around is received from the session judge. So if it is received to be released then or overturned, then it is fine. Review an order by the session judge also, when it is happening, the session judge can require additional information and must provide the individual a chance to be heard. The judge may then issue in the session judge may then issue an order deemed to appropriate regarding to release or keep the security, the arrest, the imprisonment. Multiple persons, if ordered, it is a very important part. Multiple persons ordered in the security. So in this situation where security is required from multiple individuals in the same proceeding, if one of these cases is forwarded to the session judge, the case of all other ordered to provide security will be automatically included, and the relevant provisions regarding the detention and hearing will apply automatically to these people, but their imprisonment will not exceed the duration specified in their respective security order. So if there is which is a proceeding which has gone to the session court, automatically it goes for everyone. But then suppose one of them has been given a security for 1 year or one is given for 2 years, so their imprisonment will not exceed whatever mentioned in the order. It will not be beyond that. And transfer of proceeding is but naturally it happens in the session court, in the discretion of the transfer by the session judge going to any ASJ. That is something which is but naturally flowing in the same way. Handling this particular transfer of proceeding between the judge and the additional session judge, and handling the tendered security, which is part of the 141(6) says that a person tenders the required security to the officer in charge of the jail. The officer must promptly refer this matter to the original court of the magistrate who ordered the security and await further instruction. They will wait for the instruction to ensure that the attempt to comply with the security is properly recorded and processed. And types of imprisonment is classified in subsection 7 and 8, which says if imprisonment occurred due to failure to provide security for keeping the peace, it is simple. And for case involving good behavior, as in 141(8), the nature imprisonment will depend upon proceeding under which it goes. So for peace, it is mostly simple, it will be simple. But for good behavior, it is depending upon what the magistrate believes. Because for peace, it is somebody, it's mostly a political reason for which people go inside, or for a group reason people go inside. But if you see for the cases which are otherwise, which is under good behavior, it is mostly criminal activity for which they are proceeded. In that case, it might be simple, it might be rigorous as well. So depending upon that. So it's a basically a practical implication which gives a clear consequences in case of security breach is done. And depending upon judicial oversight, a calculation of terms and conditions are given, including flexibility of judicial discretion, and also an equitable treatment using the parity process is also given, allowed to the persons in this case. I'll complete 2 more sections before we close the day so that we complete one whole chapter. Power to release persons imprisoned for failing to give security. So we talked about what the persons who are imprisoned might again who have given the securities in the previous section. Now 142 talks about power to release person imprisoned for failing to give security. Now, whenever a district magistrate, in the case of an order passed by an executive magistrate under section 136, or the CJM in any other case, is of opinion that the person imprisoned for failing to give security under this chapter may be released without hazard to the community or to any other person, he may order such person to be discharged. That is mostly in case of peace, basically. Subsection 2. Whenever any person has been imprisoned for failing to give security under this chapter, the High Court or Court of Session, or whether the order was made by any other court, district magistrate in the case of an order passed by an executive magistrate, or the CJM in any other case, may make an order reducing the amount of the security or the number of securities or time for which the security has been required. So, reduction is also possible. Subsection 3 says an order under subsection 1 may direct the discharge of such person either without conditions or upon any condition which such person accepts. So basically, for the person might be discharged if the no more a hazard, and the person could be plainly discharged or discharged with some condition that if you do this again, we will arrest you. Provided that the condition imposed shall case to be operative when the period for which the person was ordered to give security has expired. So even if the discharge is happening and in lieu of discharging even from the security period, but the conditions which are imposed for his rearrest will operative only when the period for which the person was ordered to give a security has expired. Subsection 4 says the state government may prescribe by rule the conditions upon which a conditional discharge may be made. So there may be rules also. Number 5 says if a condition upon which any person has been discharged is, in opinion of the district magistrate in the case, or which is the case of executive magistrate making that arrest, of an order passed by an executive magistrate under section 136, or in case of a judicial route ways, which is a CJM in any other case by whom the order of discharge has been made of the successor not fulfilled, he may cancel the same also. So if there is a condition, we talked about the conditional discharge can happen, the unconditional discharge can also happen. So if a conditional discharge has happened, if the condition is not fulfilled, it can be cancelled also. Number 6 says when a conditional order of discharge has been cancelled, if it is cancelled, such person may be arrested by any police officer without warrant and shall thereafter be produced before the district magistrate or the CJM, depending upon what was the route of action. Was it an executive route? Was it a judicial route? Subsection 7 says unless such person give security in accordance with the terms of the original order for the unexpired portion of the term for which he was in first instance committed or ordered to be detained, such portion being deemed to be a period equal to the period between the dates of the breach of the conditions of discharge and the date for which, except of such condition discharge, he would have been entitled to release. The district magistrate or the CJM may remand such person to prison to undergo such unexpired portion also. So such person, unless gives a security according with the terms of the original order for unexpired portion of the term, he has to complete that. Subsection 8 says a person remanded to the prison under subsection 7 shall, subject to the provision under section 141, be released at any time on giving security. And subsection 9 says the High Court or the Court of Session may, at any time for sufficient reason to be recorded in writing, cancel any bond for keeping the peace or good behavior executed under this chapter by any order made by any district magistrate, executive magistrate, etc., or the CJM. In any other case, may make any such cancellation where such bond was executed under this particular order and under the order of any other court or district. Number 10 says any surety for the peaceable conduct or good behavior of another person ordered to execute a bond under this chapter may at any time apply to the court making such order to cancel the bond, and on such application being made, the court shall issue a summon or warrant as it thinks fit regarding requiring the person for whom such security is bound to appear or to be brought before it. So this is section 142, which talks about authority to discharge. So the very first base section is the person could be discharged in case the human approach in case to see if the person is no more a risk. Then why to put these are precautionary measures. So if that particular precaution is no more required, he could be discharged straight away. And modification of the security requirement is also possible, which is mentioned in the section where the High Court, Session Court, or any relevant magistrate may choose to reduce the amount of security, etc., and number of security, etc., and they can give a relief that way also, so that the person's security duration is reduced. Or discharge of the condition. They can put a condition also for the person to be released on condition or without any condition. Regulation for conditional discharge is also discussed in this section, where if the conditional discharge, whichever is to be given, has to be given as a guideline by the state. Cancellation of the discharge is also possible, where if the condition so given is not followed, the cancellation of the discharge will happen. Arrest upon breach of discharge is also possible. So not only cancellation, the person could be arrested also. Remand for failure to provide security is also given. So for example, the person who has discharged cancelled fails to provide security for the unexpired duration of their original order. So in that case, the magistrate may remand them back to the prison to serve the remainder of the term. And release for on providing security is applicable as for section 141, and the person can be released on providing a security if he is imprisonment. And cancellation of the bonds for the higher court is possible in case for the reason recorded they want to cancel it. They have an authority to reject such any bail bonds, etc. And surety's right is also to apply for cancellation is also carried in section 142(10), which says that any surety for another individual's bond to apply to the court to cancel the bond, they can go ahead, and upon receiving such an application, the court may issue a summon or warrant to require the individual for whom the security has been bound. So if the surety is broken or the surety which was already there, if it is taken away, always the person has to be brought back to ensure he brings the next surety, which we know from the previous sections also. Let's go to the last section for the day, which is security for unexpired period of bond, which is studied in with a magnified glass. So when a person for whose appearance a summon or warrant has been issued under the provisions to subsection 3 of section 140 or under subsection 10 of section 142, previous one, whose surety has been taken away, and in previous one, the surety who was already accepted is not available anymore to be surety. So appears or is brought before the magistrate or the court. This gives a procedure. The magistrate or the court shall cancel the bond or bail bond executed by such person and shall order such person to give for the unexpired portion of the term of such bond fresh security of the same description as the original security, and every such order shall, for the purpose of section 139 to 142, both inclusive, be deemed to be an order made under section 125 or 136 as the case may be. So this is an appearance after issuance of summon or warrant, when the person is appearing where the so and so situation has happened, where the sureties have gone back And so cancellation of the existing bond is something first done, and the requirement of a fresh security for the remaining part of the bond has to be done. Now, it will be for the remaining balance part, again, he has to bring in. And in case of classification of the order, if it has to be done, the subsection 2 says that any order for fresh security issued under this section will be regarded for the purpose section 139 to 142. So everywhere this will be applicable as an order made under those sections. So in those sections, wherever the securities have failed in 139 and 142, it will be whatever order considered made under this section 143 will be considered order under 125, and as an order made under 125 or 136. And this classification serves to maintain continuity in legal process. We have seen continuity is maintained irrespective of even the specific areas of crime and civil areas also. So this is a reassessment of the obligation which is done under this section, and ensuring a judicial efficiency and consistent legal framework. This is a procedure given under so and so provision if the sureties fail, and what are the remedies for that and how that order has to be passed.